and therefore he could not have been transferred to a place where the medical facility for treatment of the same do not avail. Medical facilities for the treatment of same do not avail. First off, he points out that the place to which now he has been transferred, does not have such facilities readily available. And therefore, he is agreeable for being transferred to a place where such facilities are available in terms of central government guidelines dated.
Dated 6th of October 2020.
6th of October 2020. Next paragraph. He also tells us that his client not being able to look after the autistic child has submitted an application for VRS, and that no decision is being taken on the same. And further that, instead of taking the decision on the same, now disciplinary proceedings are sought to be initiated. First off, he tells that would be like salting the engine, which an ideal state, a model employer, state employer cannot afford to do. Next paragraph. Mr. Padley, on the other hand, submits that though the subject matter of this writ petition involves validity of transfer, he would confer with his clients in the light of observations made herein above and come back. First, for that, he seeks a short accommodation, which we are inclined to grant. First, that would call this matter on the 20th instant. A carbon copy of this order be shared with all the advocates appearing for the parties. Okay.
Item 2, WBC 240.
Just look into. Generally, in some such matters, you have to be little lenient. Advise them to consider the application for VRS. Okay. That will be end of the matter.
May I please, Your Lordship?
Yes, sir.
This application is filed challenging the order of Central Administrative Tribunal, Annexure 6.
Any urgency?
Only point is that he has rejected in the facts and circular. I have given the dates of this thing. Only notice has to go, they will get an instruction. If Your Lordship, the list of dates I have given.
This is the upgradation of the pay scale.
Not pay scale, merger. Miller, kindly Annexure 1.
Kindly come to para 8 of the impugned order.
Miller.
Para 8 of the impugned order.
Yes, yes, yes.
Reformation of
The entire case is applicant direction to the respondent application of the pay scale. Miller, that's why the challenges of this order and that kindly see the events of the list of the dates. Miller, you already
accept notice and come back. Mr. Paddy, DST requested issue note. Paddy, DST requested to accept notice for all OPs. All OPs, no? Yes, yes. Yes. Next.
Item 3. I have filed my appearance memo that was not reflected.
Just mention that. Yes.
Item 3, WBC 30094 of 2025.
And we have the opposite
Given judgment, that should may give after lunch. Because I have gone through that, it is against us. It is favor to them, it's covered. Still, I have to examine this. You
do it tomorrow. So that we will look into and come back.
Yes,
of course. Tomorrow, brother, we have difficulty. Friday.
Monday, Tuesday.
Tuesday can it? Covered by judgment.
Covered by judgment.
They are saying that covered judgment.
It totally covered.
On 20th. Posting on 20th.
On 20th.
Next.
Item 4, WBC 136 of 2026.
My lord, here, the petitioner is a mortgager. Loan was sanctioned in favor of the opposite party number 3, madam. I extended my land and building, residential land and building. the opposite party defaulted in paying the dues of the bank. It is more, loan was sanctioned for 80 lakhs. And as on today, my lord, it is 1 crore 20 lakhs, my lord.
Yes.
In the meantime, my lord, I am here before your lordship to save the property for my children, my lord.
But why did you give that by way of security?
My lord, that is the mistake I have committed. I want to rescue my children by paying the entire dues of the bank within 15 days.
But
My lord, now the development is property has been sold, sale certificate has been issued, possession has been handed over. Nothing.
when all this happened?
All this, my lord, entry is 2019.
No, my lord, 26, my lord, I was ousted. I was.
What kind of advocacy without some advocate? We are fed up with you people.
Sir,
When the property was auctioned,
my lord, it was in 2021,
21.
but the possession was taken only in the month of February, my lord.
the question is, possession follows the title.
My lord.
So title you lost because of the auction.
My lord.
That was way back in the year 2021.
My lord, that is, my lord, absolutely.
You were
correct. It is just like a mercy petition, my lord. I am ready to pay entire cost of the whatever incurred by the bank and the interest and the amount, loan amount. Within 15 days. 7 days, I will pay the entire dues of 1 crore 20 lakhs, and rest 7 days, I will pay the cost and everything.
But he should be agreeable, na?
Auction purchase name.
I will take out notice, my lord.
Let him take out notice so that he will make some payment then.
Let me
If
supply
at all.
copy of
If he agrees, we can do, not otherwise.
My lord.
Anyway, bank is safe.
My lord.
read with some copy may be supplied.
In court.
The counsel appearing for the additional guarantor of the loan in question. First off, he submits that now his client is ready and willing to settle the entire loan, outstanding amount of the loan, and further to compensate the auction buyer of the property, auction having taken place way back in the year 2021, although the possession is taken on
February, my lord. In the February 2026, my
in
lord.
the February 2026. First off, in view of the above, issue emergent notice, the panel will say notice for OP number.
My lord, opposite party number 6.
192, emergent notice to the rest.
My lord, 3 to 5 is not required. They are borrower, they are not cooperating. My lord, their presence is not
3 to
required.
5.
Only 6, my lord.
I am for 1 and 2.
Six.
I am for 1 and 2.
You are for 1 and 2 and notice to go to 6.
6, my lord, by speed post. My lord.
Notice to 3, 4, 5 is dispensed with.
My lord, I am ready to deposit the 1 crore with the bank within 7 days, my lord.
Call immediately after service. Yes.
Item
My lord, may I pray, my lord, one thing, my lord. Since he has taken possession, he may create third-party interest after receipt of the notice. My lord, no third-party interest. I am depositing the entire loan amount within 7 days.
Notice that. Anyway, matter is not pending. If he creates encumbrance, that will be subject to list pendants. Section 52 of the transfer.
Yes, my lord, that is correct. But
Chester is also pending before the third MD.
if your lordship will pass a order, then
Item 5.
That's what is always taken up. Yes.
Item 5, WPC 14766 of 2026.
May I please?
Yes.
Like here, my lord, a short prayer. The section 14 application is pending since 19/9/2025 before, my lord, the collector and district magistrate Balangir. Till that, my lord, the
That's
same.
not the grievance of the lender bank is against long pendency of application filed under section 14 of the Surface Act 2000. Yeah, Surface Act 2002. Personal. Learned counsel for the petitioner bank submits that the law has been well settled by a decision of by a category of decisions of the apex court that applications of the kind should be decided on a war footing, urgency of retrieving of public money being the primary object of the act. First of, there is force in this submission. Next, in the above circumstances, the which respondent, which OP,
Of it, but not two, my
you
lord.
have not made him a party.
Yes, my lord. Appointment 2, my
OP
lord.
number 2 is the fiction is the code of directing OP number 2 to adjudge the subject application within an outer limit of 8 weeks in accordance with law. First, all contentions of the parties are kept. Next,
Item 6, WPC 14863 of 2026.
one sentence because we have not made a particular. That the registry to send a copy of this order by speaker to OP number side. So now G appears for OP number 2, 1 and 2. Oh.
Item number 6.
This read petition against the order of Learned Central Administrative Tribunal. Learned Central Administrative Tribunal has dismissed my original application, which I have filed challenging the order of transfer.
Transfer.
Yes, transfer.
Transfer from which place to which place?
But from Bhubaneswar to Hon'Ble,
How many kilometers?
160 or 40 kilometers.
120.
120.
100.
Bhubaneswar to
Hon'Ble.
Angul. Yes.
But the Learned Tribunal,
120 kilometers.
Yes.
How long you were there in Bhubaneswar?
4 years.
What is the retention period?
Retention period also 4 years.
Then you have to go.
Let me to I'll submit. I am not challenging, I am not constituting my case on the basis of transfer policy or guidelines. My humble submission, your lordship, recent decision, my lords, it is 3 Nath case, your lordship already held, Khalid, referring that Khalid Girban case, your lordship already had, work with love or sit outside of the temple, your lordship already had. In that judgment also, your lordship has referred that Govardhan Lal case, where 3 exceptions are there. That rules must be violated, or the order is passed by the incompetent authority, or with the nullified blood. I approach the Learned Tribunal on 2 grounds. First, it is clearly against the rules. My lord, I am not saying guidelines or transfer policy. I am saying it is clearly against the rules.
Which rule?
Rules of the railway, my lord.
Say, which is the what it says?
Page, my lord, it is at page 47, my lord.
What it says?
Page 47, this is RVE number 23 of 2010, my lord. Your lordship got it, my lord.
Yeah.
Your lordship may kindly turn to next page, page 48.
Husband and wife.
Husband and wife, where one of the spouse is a railway servant and other belongs to the state service. The railway servant should be posted at the station place in the railway division PU in whose territorial jurisdiction the place date of posting of her spouse falls. Should be posted, my lord. Your lordship may kindly take note of this.
Yes.
Then my humble submission, it is not the transfer policy. It is the railway made the rules in that respect. And your lordship may aware of the railway boards versus P. Subramaniam case, your lordship may kindly take note of also.
What it says?
But
Everything we note only. Every sentence, every word we note. One we can reproduce also.
yes, my lord. But this is the rule.
But what is that?
My lord,
If such a request is made, the authority will consider it sympathetically.
my lord. Sympathetically consideration, my lord.
Yes.
Should be posted.
Should be posted
Mila.
sympathetically.
Sympathetically.
Yes, my lord. That should be considered sympathetic.
The word
My lord,
sympathetically.
Yes,
Stop the mandate of the word shall.
my lord, should be posted and sympathetical, that may be considered, my lord. Here,
Mr. Padi, what do you want?
But in way, when unfriend is, let's say, come to the prayer page 30. Just allow the original application to cause the office order number such and such.
No, that's all. Now what he said.
But-
My wife is here. Post me here.
Territorial jurisdiction means a person who is Bhubaneswar is not the territorial jurisdiction Bhubaneswar. It is the East Coast Railway on June. Suppose a person is appointed in particular place.
What is his designation?
His designation.
storekeeper.
Storekeeper.
Then every yesterday also I am requesting my law. Because of expansion one, everywhere there is a workload of this division. Suppose now this Western Odisha work is going on for learning. This
Did you make representation?
I made the representation.
That is rejected.
They have not considered as yet, my lord.
You take decision on that representation till the decision is taken. don't give
That was
effect.
rejected against which is come for way.
That is rejected.
Yes.
Yes, that we can.
But he says no decision is taken.
No. Page 42, your lordship, may kindly see.
42.
Yes, ma'am.
Mr. Padi, in our system, when Lord Rama went to Vanavas, you call it Vanavas?
Yes, Vanavas.
Yes, Vanavas. Sita went. Sita followed. And when Sita was abducted, Ram followed. Why you are against this spousal relationship?
If he is job, then you have to adopt with Tag Tapasya Balidan.
He is not general manager of railway.
But he is ready to leave Bhubaneswar, my lord. How the railway brought?
Place wherever nearby, not necessarily Bhubaneswar.
So let's make keep it some. Then I asked them if what they would be accommodate will be made.
That means very important post. Then they have to go. Yes. How many? You are hundreds of storekeepers with you. Is it your case that he has robbed the store?
No,
Not. How many years of service you have put in?
Total, my lord, 6 years.
Just 6 years.
Yes.
4 years in Bhubaneswar.
Bhubaneswar.
Do you own land in Bhubaneswar?
No, my lord, I am not on that. I am a SC/ST candidate also. There is a rule, your lordship is aware, my lord.
How caste is related? For everything, if you chant that I am SC, what the board should do, what I should do, leave the job and go for.
No, my lord, your lordship already helped me. Only 1 year back I married, and my
Only
wife
1 year,
sorry.
only
2-3 years.
that.
I will be there, and I am the last man in that depot, my lord. I am the last man.
Mr. Padi,
Plus they are
you take
transferring.
addition, till then don't precipitate.
1 year he has only.
Learned former advocate general is saying something very important.
He's saying that-
Hear that.
Then the railway disturbed, then he may have another 2-3.
Heard learned counsel appearing for the petitioner and learned DSG assisted by CGC so and so. First off, the case of spousal transfer is involved in the list and it requires a deeper examination regard being had to the railway policy now in obtainment, which to an extent comes to the aid of petitioner hearing. First off, next paragraph. Although Mr. Padi vehemently opposed the petition, now he submits that he would confer with his clients, keeping in view the representation made by the petitioner hearing in the light of the extent railway policy, and for facilitating the same, a short accommodation needs to be accorded. We agree. First off, we agree. Next, in the above circumstances, the registry to print name of learned DSG as appearing for the office, assisted by TGC number so and so. First off, are you relieved now?
No,
Till
till
next date of hearing, the petitioner's present posting and position shall not be disturbed.
Yes.
Call this matter immediately after vacation.
problem.
Next.
Item 7, contempt 2872 2020.
Page 11, your lordship's order has been violated.
Here, my lord,
One for in the above circumstance, writ appeal is disposed of, directing the authority to comply the learned single judge order. The letter and spirit in a time-bound way, as has been prescribed in paragraph 6 of the impugned order. If the timelines are not complied with, then the authority shall reinstate the appellants in service thereof.
police not Millard. It is order dated 7/4/2026 month. Just 1 month back, Millard. Yes, sir.
These are given.
Millard.
Time given. What is the time?
In 16 mile, 16.
Page 11, Millard.
Should not he argue the matter?
Yes.
Yes.
Page 11, Millard. In the above circumstances, writ appeal is disposed of, directing the authority to comply with the learned single judge order in letter and spirit in a time-bound way. The order of the Hon'Ble single judge at page 16, this is at within a period of 4 weeks. So just 4 weeks. It is order dated 7/4. Let me take instruction.
then my lord, your lordships are directed specifically. If it is not complied with in the timeline, then it shall be reinstated in service, my lord. Let them reinstate.
What action that, let me take instruction.
That ordinarily we issue a police notice in matters like this as the new practice has begun, first off. However, Mr. Mohan, the AG seeks to confer with the event and come back with some instruction, and therefore we issue notice. He accepts the first one. Mohan accepts notice for the contempt. Contempt 182. Contempt that's 182. Only one. Yes, my lord.
Only one.
Only sole contempt. All this matter immediately after vacation.
Yes.
It will be serious thing if you do not.
My lord, next week, you will not sit next week, my lord.
Next.
Next week, my lord, your lord.
Not next week, immediately after vacation. Yes.
Item 8.
Item 8, my lord,
197
that group matter. Yesterday, we have made learned AG was there, my lord.
10,000 crore.
Yeah, they are in the process that which a positive sign, my lord.
There are not seven. I heard, Lord. If your Lordship permits me, I will tell. But the economics of learned AG may be slightly wrong because pension is due to retired teachers. There are, even if you take the total number of teachers in Odisha is concerned, aided educational institution, it will never be 7 lakhs. Retired persons now claiming, I have just asked this their secretary, she was telling that they would be hardly 4,000 to 5,000 persons. That it will ultimately affect, but every year there would be a budget. And the budget is increasing day by day. How is this 10,000 crores and ridiculous?
Yeah, in fact, I felt that way. When yesterday learned AG said 7 lakh people are involved and 10,000 crores we need.
And I
You
said
can see
that
the video.
there are not
I was just thinking, because I was taught arithmetic.
Supreme Court affidavit that said it will be 40 to 50,000.
My lord, may I pray? In the meantime, we can take the instruction and what is the arrangements made therein. Let it be just after vacation, by that it will be.
That is the problem every time this we have been trying. Look.
Anyway, next immediately we'll fix a date.
Yes,
on that day. But the version of your learned AG may not be. It appears he was telling some astronomical figures.
But they,
7 lakh
your
people.
Lordship may go through this affidavit filed in the Supreme Court. They are told it will be yearly 40 to 50,000.
One for college and one for school. Total.
Where for school?
Sir, I have something to make it. I am not going to back up the about 12 times matter as adjourned. I will also look to your Lordship's order on 7 to 2026. 17 to 2026, order number 12. In presence of the learned advocate. Learned advocate and Mr. Swanso appearing to state, submit that the High Court of Orissa retired Chief Justice has been Chief Secretary has been constituted for looking into the demands of the respondent employee, and therefore a period of 2 months be granted for accompanying the facts, so hopefully in a positive way. Now, an advocate appearing to the employee vehemently opposed the proposal with capital. Since state itself is coming out with a laudable proposal, namely the constitution of the committee.
What happened to the committee? No, this it did not tell. AG did not say anything, one word about this.
The last paragraph.
What committee did?
It is in the process, my lord. It is in the process. So will come out, hopefully will come out the positive response. Let it be date be fixed after vacation. Date be fixed.
The last
We'll fix a day.
It sounds like it is all right, that it is in process we are considering, but in court it doesn't sound absurd.
Sir, you also said in the above circumstances, call this matter immediately after 8 weeks. We make it clear that no further adjournments are granted. In fact, the matter was listed again. This is the next time. That was again same thing. That and the sole question for consideration for Lordship is and pursuant to the judgment in respect of the similar matters, they have already extended the benefit by virtue of the judgment of this court, which has been relied upon by the Honorable Single Judge, and that has been upheld by the Supreme Court. And in view of now the whole question for consideration is, recently a judgment was delivered by a single judge of this Honorable Court, which was upheld in divisional bench and approached the Supreme Court, that they have already lost. In view of that judgment, since the 74 rule applicable, that they have nothing to say again, that these people are not entitled because of pension rule not be applied. That is the entire case, my lord. Only one provision, Rule B1 of 81 rules will be interpreted and has been interpreted by the Honorable Single Judge, relying upon the judgment which has been upheld by the Supreme Court. This is the entire case, sir.
On 20%.
The difficulty is, I must bring to your lordship's notice that persons are dying. Mostly now by this time, 16, 17 already dead in the meantime.
24th.
The judgment was pronounced by the same judge.
Working.
24th is
Working day. On that day, because yesterday, Learned AG mentioned when we were all absent and he made
I was told that I was also hearing
made a request.
video also I was listening to that.
In fact, he made a request. We said we'll look into this, all this, because he said some figures, etc., which you are disputing. Maybe sometimes
not disputing, not anybody having knowledge about the appointment of block grant teachers in aided education institution. 7 lakhs is inconceivable. 7 lakhs would not be total strength of teachers, whether block grant, regular governments to club together.
No, because we have said no further adjournment shall be granted.
Yes.
If we do not honor our own order,
No, my lord, I am conscious.
who will care our orders? They will say, have you obeyed your own order? Then what we should say?
My lord, 24th, my lord, proposing.
And all kinds of allegations are made nowadays in writing, oral, everything. If all this goes like this, then how judges should work?
Though he had made objections, some objections were made, lordship said that since the Advocate General on behalf of the state says 2 months, we must grant 2 months time, they must come.
Your lordship heard that
We make it clear that no further adjournment shall be granted.
Yes, my lord.
That those orders bind the judges also.
Yeah, obviously.
Now, this your AG did not tell us that there was such an order, nor any one of you who were present also did not say. We'll call this matter on 21st.
24th, my lord.
21st.
21st is the holiday.
No,
21st.
Next week.
Next week.
My lord, yesterday.
Since he said something, and they were.
No, will not be available in the coming week, my lord, because of the. Just after.
He said you are as competent as himself. Yesterday he said that he appreciated all of you. When I
may pray any hopefully any decision may come out. May pray just after the reopening, my lord. Let it be on 22nd or the 24th.
Keep it to 21st.
21st. Keep it. You tell what your committee has done. See, the English word process is a dangerous word because it can be the cosmic process also. By that time, everybody would be dead. Me, perhaps you may live, that's another thing. But many will be dead.
And since the matter is pending, though the contempt application are being filed, we have taken on our behalf from the single judge who don't want to pursue because the matter is pending.
May I pray after vacation, my lord, that is on 23rd or 24th.
No.
But something will come out, my lord. Because
In that event,
Really, we are sorry. Nothing comes out. See,
in that event, let them discuss. My lord, may I suggest something? In the event, let them take time, they give the provision from some subject to our undertaking that if he does, we'll
So, unless we interfere, nothing happens.
21st, learned AG.
We are running the government also to some extent. Courts are running the government. That level it has gone down. It has become inevitable to the judiciary.
I only pray, my lord, because
we are posting this matter. Ask your AG to come and say something. Because yesterday he should have said, sir, there is an order that no adjournment shall be granted. He did not tell that. Had he told that, we would not have granted adjournment at all. Because we have to obey our own order.
Yeah, obviously.
Should not your AG tell that there is such an order?
So at the time of
Mention, everybody is upset.
at the time of mention, it is being done, my lord.
No, generally, in all high courts, AG is the constitutional functionary. Therefore, we go generally.
May I pray, my lord? Let it be in vacation.
These are fair to
Let it be after vacation. By that
20th, we have 20th, this matter on 21st.
21st.
Just right now, this on by your order dated 17 to 2026, we had said as at first time. Yesterday, when the matter was posted, the request was made and matter is posted today. Yesterday it was there, na? Yes,
Yes, ma'am.
posted today.
Yes, it is.
First time. Learned counsel, Mr. AG, Mr. Mohanty, in the light of discussion that took place in another matter between the court and in another matter wherein learned advocate general had appeared, submits that this matter be called after vacation. First time. Learned senior advocates from Mr. Mohanty, Rothrai, and the other advocates on record vehemently opposed the proposal for adjournment, drawing our attention to the above order, wherein it is mentioned, it is stated into inverted commas. We make it clear that no further adjournment shall be granted, inverted complete. First time. Therefore, in the above circumstances, very reluctantly, we adjourn this matter to 21/5/2026 for have the say of 26 for consideration. Okay. On 21st.
Can interact.
Two. Suppose if we do not sit that day, it will go. You take that.
Let it be in the board, madam.
Yes. Yes, next.
Item 9, State Appeal 1012 of 2024.
Mr. Mohanty, you have to say what the committee has done.
What steps we have taken so far?
That's it.
What is that process?
Yes, ma'am.
What the committee mentioned in the above order
Miller
has done.
Apprise the development of the matter.
Above order has done, needs to be stated. First off. At the same time, the names of committee members should be disclosed to the court so that it can take some punitive action if there is any lapse on them. Give their names. Yes. You can't go on playing with the retired people, lives of the retired people. Many are dead.
Item 9, State Appeal 1012 of 2024.
State appeal, Your Worship, it is similar to yesterday's item 13. I have just given the copy of similar order. I also served a copy of my learned senior as well. It was discussed on daily as well as on merit, Your Lordship. Yesterday's item 13. The regulation of any assistant working in Sambalpur University.
Lordship, may kindly have a look to the order passed by your Lordships.
Today, on my mention, it has come today, Your Lordship.
1/6/2023. 1/6/2023, the date of the judgment. My lord.
Impugned order.
Impugned order, my lord. Paragraph 13.
1/6/2023.
Yes. Paragraph 13.
In the analysis.
In the final analysis, in the light of the foregoing discussion, the impugned order dated 31/5/2019 passed by the government of Odisha and the Department of Higher Education, Odisha, under Section 2, under Annexation 12, in rejecting the claim of the petitioners for regularization in the post of junior assistant in Sambalpur University cannot be sustained in the eye of law and is hereby set aside. The opposite party shall pass appropriate orders for regularization of services of the petitioners against the posts of junior assistants as expeditiously as possible, preferably within a period of 3 months. My lord. Here, my lord.
How many years of service?
The Sambalpur University.
How many years of service?
13 years, more than 13 years, as on the date of filing the application. Now it was more than 19 years, Your Lordship.
Now, my lord, the Sambalpur University has given them appointment.
University
Without
has
taking- my
Given
lord,
an appointment.
no, they have engaged him, engaged them,
Yes.
without taking any consent from the finance department of the government.
Which law says university should
Well,
take consent of the government?
Unless,
Otherwise, university becomes a department of the government.
Yes.
The object is to give autonomy to the university. It is not your department.
No, my lord. Then they should have regularized them.
How you are concerned with this?
We are not concerned, my lord.
Then why are you
Regularize. Then let them regularize, my lord. Why they are taking
Your Lordship, similar
We have got
matter,
nothing-
state judgment
because-
appealed by this honorable court.
Because
Given
your
the
lordship
state
directed-
has already been appealed.
No, how you, when the university is the employer,
Yes.
university will decide whether to challenge this order or not. How you are concerned?
Because
you
your
can
lordship-
tell to the university,
Because-
you have made this, we will not give money to you.
What has happened is they have given a representation
Yes,
to this. That was rejected
rejected. By whom?
by the state,
Huh?
by the
state.
government,
Government.
my lord.
Government rejected.
Yes,
Did you mark that representation to the university also?
Yes, Your Lordship.
my lord. They are the employer.
Well, let us see no, we are asking what is your locus standi to challenge this order?
Exactly, but because the order
Order is issued to whom?
is issued Sambalpur University.
How are you? University is not a part of your department. It's an autonomous
It's the
body.
opposite parties. Opposite parties means
We'll
we are-
say opposite parties means university.
If I just
Oh.
be allowed. Similar matter, same judgment out of the same common judgment, Your Lordship, has already been upheld in writ appeal by Your Lordship.
That's
I
all
was
right.
given the
There,
order.
this question was not raised. There, this question, we read that order. He says, without our consent you have appointed,
My-
that will affect drill a hole in the state exchequer. Therefore, we have locus standi.
and direction was given to the opposite parties. Opposite parties.
They should have said
Yeah.
opposite party means university, vice
University.
chancellor.
That's not.
They have not. They have to do this, etc. How can? Where is the vinculum juris between you and the government? Who are you to the government?
My lords.
State
It also delayed 305 days, Your Lordship. Not
300.
5 days.
The state and its only state government.
No, it is state government, vice chancellor, Sambalpur University.
Who are all the appellants?
No, appellant is only.
Appellate or
state.
only state.
State.
How can it?
And the university is not coming.
No,
Then did you ask university why you regularize? You have appointed these people. Why you should not be removed? Why your salary should not be withheld? Did you tell it to the registrar and the vice chancellor?
no, we are.
And then why are you falling on poor people?
We are not, my lord. It is
No,
the
I said,
university.
why are you in the appeal before the court?
Because there is a direction against us. That's right.
Did you take up your contention before the learned single judge? No direction can be given against us. Where is your reply?
No, that's also.
Then, having allowed the learned single judge to so slip into this dip and now saying that no, he could not have done something to us. Because throughout we have been seeing orders, you are treating the universities as if they are your departments. They are not your departments.
They are autonomous.
They are autonomous bodies. They are not bound to obey the government.
Yes. They have their own, so far as teaching staffs are concerned.
Yes, if autonomy of the educational institution is lost by interference of the government, then how the country will come up? Your officials treat the chancellors, the vice chancellor, registrar, etc. as part of their subordinates. They are made to wait outside the chamber. We have made that observation in one matter.
Yes, in one matter, your lordship.
Right. State is in appeal in this intra-court appeal in personal. It seeks to lay a challenge to a learned single judge's order dated. And go to the order. 1/6/2023, whereby respondent, how many employees? Only one?
Yes, only one.
Yes,
Respondent employees.
No, there are others. No, only one.
Only one.
Only one.
Respondent employees WPC number 12484 of 2019 having been favored, the following relief has been conferred on him by the him, that operative person, no? Or clash directly to regularize, etc. Next one. The appeal is moved after booking a long delay of
305 days.
305 days. Can be seated. And an application supported by an affidavit accompanies the appeal. We'll condone the delay, brother.
Yesterday's matter similar.
Then let him file objection.
Your Lordship has dismissed the.
No, that delay individual matters.
On delay. Yes,
Delay.
as Lordship insists.
Some explanation has been offered showing the circumstances that resulted into delay. First one. Learned Counsel AGA also submits that throwing away the matter on merits on delay alone would not do justice to parties. First one. Learned Counsel appearing for the employee very fairly submits that the application be allowed. First one. However, he vehemently opposes the matter on merits, contending that the state is not a person aggrieved, and therefore it does not have locus standi to maintain the appeal. First, next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, sentence or not, application is allowed and delay is controlled. Yes. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter in as much as the state government cannot treat the universities as its departments. Its departments, in as much as these universities are creatures of law and their affairs are governed by the Orissa Universities Act is there.
Yes.
The Orissa State, what is the name of that?
My Lord.
Statute.
The Orissa State Universities Act, is it like that?
It is statute.
They have their separate statute under the Orissa University.
I'm just giving it that your Lordship.
Statutes are made under the Act. Okay, that judgment, take out the judgment. There is a difference.
That is the Orissa Universities Act 1989.
1989. First off, the provisions of the Act apparently confer autonomy on the universities. And it is the university which happens to be the employer, comma, and not the state government. First off. Therefore, in matters relating to appointment and regularization being one of the modes of such appointment, comma, it is the university which has to take the decision. First off, the availability of finance is a point apart. And that should not affect the autonomy of the university. First off, therefore, we find force, which is that judgment where the Supreme Court said the government cannot interfere in the affairs of the university. Take out that judgment. Next paragraph. No, one sentence. Therefore, the state in our considered view lacks locus standi to maintain the appeal of the kind. Next paragraph. The above being said, learned AGA Mr. G is right in telling that the learned single judge ought to have, should not have directed the state government to take the decision in respect of the claim for regularization of service of the employees of the university. First of all. However, we do not see any pleadings taken up by the state government before the learned single judge in this regard. First of all. Therefore, much deliberation need not be made in derogation of what we have stated in the subparagraph supra. Next paragraph. All the above being said, comma, learned counsel appearing for the respondent employee is right in drawing our attention to writ appeal number 1222 of 2025 between State of Odisha versus Ranjan Kumar Raut, decided by this court. By us.
Yes, Your Lordship.
No, that not this all right, but the one which is referred in
Yes,
that.
Your Lord. Yes, Your Lordship.
But brother was not. By another bench.
By coordinate.
Decided by the coordinate bench of this court by order dated 21/1/2026. First off, even this bench has followed the said decision in writ appeal number 971 of 2024 between State of Odisha versus Sudhakar Barik and others, decided on 9/3/2026, whereby appeal of the kind has been negatived, of course, on other grounds, in addition to delay. First, in the above circumstances, this appeal being unworthy of credentials is liable to be not admitted, rejected, and accordingly it is, courts having been made easy, first off, the appellants to implement order of the learned single, not appellant,
The party number two.
the respondent number
2 and 3.
2 and 3. We are not issued. No. We can't give it to that level. We can't make any order because they are not before us. We are dismissing at the admission statement.
In 1/222 also, Your Lordship, this bench has passed the order according to Chako and Shripad. And Mr. My learned area was also a party to that.
No, but my brother was not there.
Yes, sir.
Other brother was there.
No, Your Lordship.
Huh?
Same bench.
Same way.
Same bench.
On
Same
21st
same
one.
judgment. On the
21st
judgment on 21st of January 2026.
No.
Who were the bench composition? What was the composition?
Can I just
Read.
Should I read, Your Lordship?
Read.
Or CORAM, Mr. Justice Dixit Krishna Shripad, Mr. Justice CHITTARANJAN Das.
That's the order.
Yes, Your Lordship.
Then instead of coordinate, this bench should make it this. Okay? Fine. Just look into it.
Right.
Yes.
I'm grateful.
Item 10.
I please, Your Lord. It is covered by the Naru Pradhan and Basan Das case. Your Lordship, as the last time, first a short order. I have given the copy. Your Lordship, last time, taking into Your Lordship judgment, passed a short order.
Have you changed the factuals?
Then I will correct. Kindly change it. Your Lordship, permit me, I will correct.
What set you have to change now?
The 3 cases are there.
May I add that Puttandra only counsel.
That's what. Appeal decisions. Delay, how many days delay?
Those 200 days.
Your Lordship already do.
Condone. Money you have received.
My lord,
No, not put to medical, the financial condition.
no.
All.
Item 11, read appeal 2586 of 2024.
Yes, yes. Covered by this. Yes.
May I please do answer? The petitioner is a constable Miller in CISF. Removed from service Miller. Of course, this one was put in read petition. The petition was dismissed and
Why dismissed?
dismissed on the ground that petitioner had manipulated the doctor's reports in the place of rest. He has added bed rest. So that is that was.
He has provided bed.
There's a blood
That
doctor
is
said
event for
rest.
rights
I have added. Last 15, 16 years he was in one place. Even that he only written giving application that I am bed rest. In CISF is a parameter put. There was constitution of a medical board. Medical board.
He did not appear before the board.
Medical board said he is unfit to resume work.
Medical board is?
Medical board said he is unfit to resume the work.
Where is that?
That is. That document has not been taken into consideration by anything. You also read petition, you also read petition 4232 of 2018, arising out of this double filing. So last can you see page 24 minutes. Request from the authority to the medical to constitute a medical board. Page 24 minutes. The report report is at page 65.
No, that he appeared before the medical board. He appeared before the medical board.
Yes, madam.
Huh?
The report has come, that is why, unless he appeared, how the report.
No. That he can do.
2007, I joined in the year 1986. 18 years I worked. I fell ill in 2004. I took leave. The battalion, 6th battalion medical. There I was treated for 11 days. Thereafter, they said to take.
Where is the order of single judge dated 21/7/2007? Show that order.
Read up.
Where is that order?
That is at Annex 2. Next one, go to the readabilities.
Oh, 2017. What is the implement?
19/4/2024.
No. What is the implement?
That is Annex 2. Next one is base 39 of the 2586 of 2586. Page 13. Page 13 let me see the.
One second. But the single judge says, you have violated the order of the writ court. When he said, I read this. Whereas he said, he has manipulated the records also. Inserted the word bed before rest. Yes, on the prescription. Why that person should be allowed? He may manipulate anything. He may manipulate, if he is given power, he may manipulate the constitution itself. One word, introducing one word, introducing 1 0, you know what will happen.
In Article 4, he has been charged that he is in the habit of absenteeism, and earlier 6 times in the past he has been given punishment. 6 times.
6 times. Why such people should be retained in the service?
And there was an expert inquiry because
All right, about what about earlier 6 times?
I could not defend that.
Dismissed. Yes. Next, show me.
Yes, similar to item number 2.
Item 12.
Send it to say
Item 12. Date appeal 316 of 2024.
Yes.
If not, you can.
Item 12.
Yes, sir.
My lord, item 12 and 13. Both the cases, Lordship may call this matter next week. I have got the file, but I am not ready.
After vacation, at the request of the meeting chief. Yes.
Item 13, my lord, item 12, I am appealing. Most that promotion matter is there. I have to.
12 and 13.
Item 14.
Immediately after.
Item 14, WBC 27576 of 2024.
Yes, sir.
Reading some 2 rounds, I have to add it. My lord, I want that
You want to take additional grounds in appeal?
appeal. That specifically the tribunal has been referred one judgment. I have not dealt with it, that is the reason. I just 2-3 paragraph. I also saw the copy to the president. And that is the IN number 9395. That has not been come. There is a hard copy of me.
Not come. Push this matter.
With your lordship's kind permission, if I can make a mention. The point he is raising by way of amendment, my lord, these are all legal points he is raising. He can raise it. I have no problem, my lord.
No, that
Let him argue the matter.
Immediately after vacation, get the request.
Last week it was there.
Yes.
Today it was specifically fixed for hearing.
Next.
Item 15.
After vacation. Yes.
My lord, I believe not the contempt matter is there.
We are precipitating the
My lord, they said they are coming before this honorable court after the expiry of the time granted by the tribunal. We have already filed the contempt after notice is.
after vacation. In the meanwhile, no contempt proceedings shall be precipitated by the tribunal.
Can I just make a prayer, my lord? I am ready with this amendment, my lord. Can it be hard right now?
After IA has to come. He is seeking, never he seeks any adjournment. He is saying,
No, I am
IA has
not objecting to his amendment, my lord.
He should pose a.
Let him have his amendment.
Follow in
I am ready, my lord.
the second week of June. Yes. Next. July. Yes.
Item 15, Date appeal 2 of 2025.
Yeah. Okay, I'm not understanding. short accommodation, government advocates will seek. Already we are falling on. I think we should not give wherever the takes us.
Item 15.
15. None appears. It is dismissed on the ground that it has become stale. Is it new? How can a service matter relating to terminal benefits become stale? You would take notice. Issue notice. Learned AGA Mr. G on our request accepts notice for the OPC. Yes, next.
Item 16. Read up in 54 of 225.
Item 16, pensionary pension matter.
Understand taken in the counter and I abandoned service.
Let me complete. Let's kindly have a look to the order passed by the learned single judge 21/2/2024.
21/2/2024.
24.
Impugned order.
Impugned order.
Paragraph.
Annexure 4. Paragraph 4.3. The ordering portion, learned counsel for the petitioner contended that. No, sorry.
No.
I'm sorry. The last 6.2.
6/1, 6/2.
My lord, 6/1. In view of such inaction on the part of the opposite parties in not taking any action against the deceased employees for his remaining an unauthorized absence with effect from 1/12/1989 till he retired on 31/5/2009. It is to be held that the petitioner's late husband continued in service till he attains the age of superannuation on 31/5/2009. However, considering the fact that the deceased employee prior to his death never was sanctioned with pension, this court, placing reliance on the order passed in WPC OAC number so-and-so, held the petitioner eligible and entitled to get the benefit of minimum family pension from the date her husband died on 23/6/2019. This court accordingly directs the opposite party number 4 to take effective steps for sanction of minimum family pension as due and admissible with effect from 23/6/2009 in favor of the petitioner and release the same with arrears. My lord.
23/6/2019.
The date when he died. He died. My lord, here is the case.
What is the qualifying service for pension?
Minimum pension is 10 years.
10 years. Now he has put in 20 years of service.
20 years of service. By then, when he left the service, my lord,
yes,
the 81 rules was in force. Yes. 89 he left.
Left means?
Left means, my lord, I'm giving some dates, my lord.
No, that we'll assume whichever date you want, we'll assume, no problem at all. Left means what?
Left means, my lord, the husband of the petitioner, he remained unauthorized absent.
What, did you call him back to the job?
No, we had not.
You have not. Did you take any action?
Till the date of his retirement.
That is what he is saying. No action.
What is
no action?
You should have sent a, you should have shooted a letter saying, brother, you are remaining away from service. Your services are very essential. You are Vishwashriya of our state. Come and work. Where is that letter?
My lord, that he remained unauthorized absent.
What action you took for that?
1/12/2089.
Very well.
Till he.
What you took that action?
No action has been taken.
You should have hanged him to the nearest tree. You have not worked
no
for the
action has
state
been
despite
taken,
being
madam.
appointed.
Yes.
Either you quit the job or you come, we want to hang you to the nearest tree.
No,
Where is that version?
There is also a ground, my lord, when somebody left the job voluntarily. But that means he has abandoned his service.
Where have you stated that? Where have you taken up those pleadings?
Pleadings only we have taken the.
Where is the pleading?
The original, it is not there.
No, nothing like that.
While deciding the learned single judge.
Not a single letter he had.
Not even a letter is said.
No. No proceeding, nothing else.
Nothing, no proceeding. What the widow will do? She also suffers when he goes away. Or even when, suppose if a man is staying at home, it will be a torture to the woman throughout. Which widow, the wife will keep quiet. Why you did not? There is a action should be taken against higher officials for allowing him to retire so peacefully, hovering in the Katak market, Pakshi market. You should have taken some action against officers who did not take action against him. Now he is dead and gone. What the widow should do? So you want to dilute our opinion?
No, minor
Doing like that.
minor subordinate that issue. That I on. Government matter, I already decided this now.
Identical matter is
Decided that I on this.
Similar case.
Yes, similar issue. Abandoned service. That custom minor dismissed and paragraph 4 point paragraph 4. Paragraph 4 minor decided this. That I only.
So in one case we held for abandonment of service, there need not be a formal order, which is my judgment. Take out that.
Like upon the Union of India,
This one
We are held against you in one manner. Take out that judgment. In cases of abandonment of service, ordinarily the order should be passed. But however, that is not the thumb rule. We have said that. Take out that. Requires consideration. Issue notice. Doesn't it counsel saying so and so appears for respondents. The matter requires deeper consideration in view of our addition. Give that judgment. Call the application. Yes.
Item 17, read appeal 65 of 2025.
My lord, appeal by the state involving delay of 274 days. But on the merit of the case, my lord, that higher qualification, lower qualification, when the candidate has secured the higher qualification, apex court decision is there. Also, your lordships have also held. That Puneet Sharma, Himachal Pradesh State Electricity.
That was mentioned in the impune order. And also, my lord, they have the rule also they have incorporated that higher qualification.
Subsequently, rule has also been amended.
For the post of pharmacist, my lord,
They have implemented
I was selected by staff selection and my candidature accepted. I got appointment. After continuing for 1 year, they have removed from me service. Then I have challenged before the Honorable Single Judge and Honorable Single set aside as remitted matter. In the meantime, they have also reinstated matter to me. Now I am continuing. Thereafter, they have preferred the appeal. And the rule is also in my favor because the government has amended the rule that bachelor in pharmacy is also acceptable for the post of pharmacist as for the Pharmacy Council of India Act, my lord. And your lordship that referred in the impune order the Rakesh Borey case, that is also a pharmacist and that has gone to Supreme Court, that was dismissed. They have also
identical matter.
The Honorable Single Judge has mentioned that one Rakesh Borey, para 6 of the impune order, that was gone to the Honorable, they have implemented. Apex Court has dismissed the SLP and...
this is the judgment I was...
My lord, my lord.
You were removed because you possessed higher qualification.
After continuing for 1 year, staff selection and...
You were appointed on which date?
My lord, I was appointed on 30th 10 2021 as pharmacist, being selected by the CDMO after
selection.
My lord, the staff selection commission has selected me,
recommended your case, sir.
Recommended to the CDMO for appointment, and the document verification was
for advertisement.
My lord, the advertisement.
And that select list is dated what?
The select list, my lord, that is advertisement, the printout of the application letter. That is Annexure 6, my lord.
That is written list. Annexure, page 26, I have given the select list, my lord, of the single bench writ petition. The select list.
This is the provisional select list.
This was the select
This
list.
itself is the select list. Dated
That is, and there is, my lord, on 4/9/2021. Schedule cast, that is the page 29,
your
page
your
30.
client is a member of scheduled caste.
Schedule cast. Page 30.
4/9/2021.
My lord?
4/9/21.
4/9/21 and thereafter the.
My lord, thereafter, my lord, the appointment order was annexure 7.
13/10/21.
My lord, my lord. Thereafter, I was allowed to continue. And by the impugnment, my was cancelled and that was set aside by the. Right, annexure 10 on 3/12/21.
What is your qualification?
My lord, bachelor in pharmacy.
B Pharma.
My lord.
And what they wanted?
They have stated that there should be diploma in pharmacy.
Okay. That is the only ground.
That is the only ground.
Take down. Nothing. This appeal 17. This appeal, intercourt appeal by the state seeks to call in question. Kindly be seated. A learned single judge's order dated 4/3/2024, whereby correspondent employees WPC number 1690 of 2022 having been favored,
with a direction to consider the case of the petitioner.
The following relief has been conferred on Para9. How many days of delay?
274 days.
The appeal having been instituted after brutally a long delay of a delay of 274 days, an application in IA number 3, no, IA number 14, correct?
Yes, my lord. Yes,
Of 2025, supported by affidavit, accompanies it, seeking its condonation. Seeking condonation. Okay. The perusal of the application does not make out any case for condonation of delay, there being no plausible explanation, as rightly contended by the counsel appearing for the employee. First, therefore, we dismiss the application. First, next paragraph. Despite dismissal of application for condonation of delay, we have undertaken examination of the matter on merits for our satisfaction. First, the respondent was in the open market for appointment, and accordingly, on the basis of select list dated 4/9/2021, prepared and published by the
Odisha Subordinate Staff Selection Board.
Selection Board.
Commission.
Selection Commission.
Commission.
He was selected and recommended for appointment. Accordingly, the formal appointment order dated 30/10/2021 was issued as a pharmacist, and the respondent joined the duty accordingly. First time. However, he was disengaged from service by the order
dated 3rd December 2021.
3/12/2021, essentially on the ground that the prescribed qualification for selection was diploma in pharmacy, whereas the respondent employee had obtained graduation in pharmacy. First time. This reasoning having been faltered, learned single judge has handed the impugned order in favor of the citizen. First of all, the reasoning of the learned single judge accords with the view of Apex Court in Chandrasekhara Singh.
Punit Sharma.
No, Chandrasekhara Singh versus State of Jharkhand. The latest decision reported in 2025 Live Law SC 336. First, learned single judge has referred to similar decision earlier rendered in so and so.
Para 6.
Para 6.
My lord.
Let's look into that. Next paragraph. In the above circumstances, this appeal fails both on delay and on merits. First, the impugned order of the learned single judge shall be given effect to within 4 weeks.
I have
already
reinstated after filing content, but the dismissal to till reinstatement on the ground of writ appeal pending, they have not regularized.
When are you going to regularize that?
That period.
Because consequence will follow from your lordship judgment.
Consequential benefits.
One more, again, he has to come before. We don't take it. Last one more grouse. We are told at the bar that pursuant to order of the learned single judge, the contempt proceedings were initiated in a contact number. So and so. And thereafter,
3605 of 2024.
Under the threat of the court, the order of the learned single judge has been partly complied with by reinstating the respondent employee
on contractual basis as if a new appointment.
On a contractual basis, as if it is a new appointment. First time. This may not be correct. The Apex Court in that Sahu, that district judge, Sanjay Sahu versus so and so, has specifically observed that once termination order, be it compulsory retirement or otherwise, is set at naught, the reinstatement should be followed by payment of the back papers and other service benefits. First time. Therefore, this therefore the impugned order of the learned single judge has to be implemented that way. Next paragraph. In the above circumstances and with the above observations, this appeal fails both on delay and merits. First, compliance of the impugned order of the learned single judge in letter and spirit, in the light of what we have observed above, shall be done within an outer limit of 8 weeks without driving the respondent employee to one more legal battle, which is otherwise avoidable.
My lord, one clarification is also required because one Devendra Deep matter is also a challenge in the Supreme Court. It is pending consideration.
That is altogether different
footing.
That is true. But here he was appointed. Thereafter he was terminated.
Similar cases, if Supreme Court is in session, my lord, then
that's how judgment here today. We may be wrong.
But Rakeshpuri case,
we have power to where we have to see the justice. Otherwise,
yes,
all one case after another case, a citizen will be harassed. We have seen the teachers who have retired and they suffering, etc. They will curse us. They will curse not you people, government, but they will curse the judges, saying that all facilities are enjoyed by the judges. They don't do their job. They don't understand the difficulties of common men. That's how people speak about judges nowadays. Yes. So let's in a crucible of minutes, we'll come back. Yes.
Item 18, Writ Appeal 67 of 2025.
This matter.
Yes, sir.
It's 99 days so lordship delay.
Number
19.
Yes.
99 days.
What is the on merits?
Lordship, we taken 2 grounds, lordship. Lordship, here is advertisement for distribution of LPG, lordship here. And the cut-off date was fixed for certain date, lordship. The respondent number 6 rectified his defect after cut-off date and they allowed him. And that was my entire submission before single judge, lordship. The conditions of the advertisement cannot be altered after cut-off date.
What is that alteration?
Lordship, stated lordship can come to eligibility criteria, lordship, the advertisement.
Page number?
Page number, lordship.
Election 5.
Lordship, I'm showing lordship, I'm showing lordship the condition, lordship. That is at lordship. Page 25, lordship.
Page 25.
Eligibility criteria starts from clause 7, that is at page 24. The relevant person is clause Roman 6, lordship, that is lordship, the offered land, lordship, for
should own a plot of land
lordship
of adequate size
with this lordship 15 km from the municipal oblique town oblique village limits of the location offered in the same state for construction of godown for storage of 8,000 kg of LPG or ready LPG cylinder storage godown as on the date of application. As per the other conditions there, the state lordship come to their admission in their counter.
on the date of application.
Lordship, on the
When he made the application?
Lordship, the cut-off date was lordship.
No, it does not say cut-off. It says as of the date of application.
Application means lordship, I'm giving the date, lordship. Before cut-off date, he applied lordship. The cut-off date says lordship 20, lordship, cut-off date was 25/4/2012, lordship. 4/2012.
That is last date for applying.
Last date for applying, lordship.
That notification is dated?
Dated, lordship, 25/3/2012, lordship.
What is
25/3/2012.
What you call it?
Lordship, that is an annex of the advertisement, lordship.
Advertisement.
Advertisement, date of advertisement, lordship.
Notice for appointment of LPG distributor.
LPG distributors, lordship.
25/3/2012.
Lordship, state have come to their counter, page 113, para 6. Their own admission, their counter, lordship, that is
114 of the writ application, Lordship. Para 6 of their counter, opposite counter.
Subsequently, field verification of that part of the paragraph.
Lordship, para 614, Lordship, internal page 2.
Paragraph 6.
Para 6, Lordship, last 5 lines, Lordship, field verification of.
That's what, subsequently.
Subsequently, Lordship.
Subsequently,
field verification of credentials was carried out.
One second, you are too fast. You are not allowing us to think.
Sorry.
Subsequently, field verification of credentials was carried out wherein the land offered by the selected candidate was not found to be as per the requirement, and accordingly alternative land was asked to be provided, and the same was found to be suitable. Petitioner raised some objection which were answered quite explicitly. So
they relied upon Lordship because there is a clause under the advertisement. Further clarification can be, Lordship, conferred from the applicants. Relying on taking advantage of that clause, Lordship, they are saying, because we have allowed him to rectify his defects, and he has rectified.
Whether that rectification was done within the cutoff date?
No, Lordship.
Subsequently,
Lordship.
Any provision in the notification which gives some relaxation?
Clause 9.5, Lordship.
Just read that.
Page 34, Lordship, clause 9.5. Application would be received in sealed envelope only. After application is received, serial number would be put on envelope and also recorded in a register. Acknowledgement of applications received will be sent to the applicants. In case of deficiencies are found in the application, a letter would be sent to the applicant to rectify the deficiencies within specified period of time.
What is that time?
So, Lordship, as given by the authorities, Lordship, that is ought to have been, Lordship, after verification of the documents, opening of the advertisement, they will found it if there are deficiencies. But my humble submission, can they make eligible ineligible person after cut up, Lordship, for example, Lordship, I have not given a proper residence certificate. So it can be rectified that it can be a proper certificate. Can I change my residence certificate after the cut up date, Lordship? That is my humble submission before Lordship. And Lordship,
you take notice, Lordship. How various high courts have, because similar matters were decided by HSI. Do you have any judgment?
I have, Lordship, brought some judgments, Lordship. But my another one submission, Lordship.
Sure, this will go to another next. Why another? Where the admission starts.
Very cryptically only I given only the citations, Lordship, not in detail, Lordship. But another fact, Lordship, to respond to 6, now he is no more interested, Lordship, to take that LPG distribution, Lordship. He has already sold out this property, which is under dispute, to another person. And Lordship, he is not interested to participate in the proceeding also, Lordship. I am the only candidate available, Lordship.
Let us issue emergent notice to 1 and 2. Emergent notice, first of all. Learned AGA is requested to accept notice for 3, 4, and 5. First one. See, emergent notice to 1, 2, 6. Learned AGA, Mr. Panda, will you accept notice?
My lord,
request accepts notice. Learned AGA, Mr. Panda.
But he should supply a copy.
Accepts notice for 3, 4, and 5. First one. Petitioner, the appellant to supply full set of paper book to Mr. Panda. Has supplied full set of to Mr. Panda. First one. Requisites within 3 days.
May I status quo, Lordship, they should not cancel or
Which cancellation? You are holding it now?
No, Lordship.
No.
There is still it is to be finalized. They may, Lordship, come up with, Lordship, to
Let us see. Yes.
Item 19, Rate Appeal 412 of 2025.
Wait, please, Your Lord.
Yes.
For the respondent, Your Lordship, they have already submitted, the delay has been condoned. They have already submitted the requisite fine which Your Lordship had enforced upon them, it is already over. Lordship, my humble submission is let it be heard today, Your Lordship. I am ready with the arguments, Your Lordship. Let it be heard, Your Lordship. I prepared a small date chart for appreciation of Your Lordship.
But you can be merciful to the judges also.
Lordship,
Where is the urgency?
the urgency is that, Your Lordship, I am actually serving in the OPS cadre, Odisha Police Service cadre. Now I am to be supposed to be promoted to the IPS cadre, Your Lordship. In this writ appeal, there is no stay. The single judge order is in my favor, in which they have allowed and stated that I should be allowed to continue in the OPS cadre. The only impediment is that, Your Lordship, because of the pendency of the writ appeal, which has been filed with a delay, they are not allowing and recommending my name to the IPS cadre, Your Lordship, which is now to be finalized, Your Lordship.
No stay, nothing.
No stay, nothing, Your Lordship.
But we'll fix a date and we'll dispose of.
Lordship, may I pray, Your Lordship? Lordship, Lordship, may I fix a date, Your Lordship, a short date may I fix.
Immediately after call this matter.
Lordship,
24th of June. 24th of
may I pray, Your Lordship? Lordship, the issue is that, in fact, I have mentioned it in the last week, Your Lordship. It was in the weekly list. I mentioned, and Your Lordship allowed to be.
20th June is just 1 month away, na?
So, Lordship, it is going to be finalized in the month of May, Your Lordship. That is the only issue, Your Lordship.
In the meantime, also, I will be fully prepared, with I will solicit the instruction.
That day you
And that day it will be completed. I undertake.
Lordship, let it come along with another writ appeal, Your Lordship, which is in a similar matter. Item 11 in today's list, Your Lordship.
11.
Item 11 is
WA number
the weekly list.
WA number.
WA number 1348 of 2025.
That.
Item 20, date appeal 467 of 2025.
Yesterday's list, my lord.
Forward matter, my lord.
Have you changed it?
My lord, all orders is the same.
Identical.
Yesterday, item 17 was there.
A batch of hundreds, like writ appeals, Your Lordship decided recently, every day.
Yesterday, item 15.
Fixed health unit, mobile health unit. That.
May I pray, my lord? Two others.
Two other matters.
Yes,
Ask them to post it. Ask them to send the papers at 2 p.m.
Item 21, date appeal 700 of 2025.
Yes, sir.
This matter is also analogous with the WA number 197. It's today it was in the list, my lord. But involving a delay of 800 persons. We have to pay the cost for 16,000 some odd.
Because 4 days. But the matter is covered by the judgment.
No, not covered. It's analogous.
Sharat Chandra one.
Analogous with 197. 197 by 24. That was in the list today also.
20 rupees per day.
That
same order.
Item number 8. Today's item number 8.
Item number 8.
No, that is no. That you have that you have adjourned.
Yes.
197 is correct.
That is 20 rupees.
20 rupees per day, my lord.
Per day. It should pay.
Item 22, date appeal 11. Item 22.
My lord has adjudicated similar matter in this adjudication.
Covered by judgment. Is it covered by judgment?
Yes, ma'am.
Have you shared a copy with your friend?
Yes. Covered by the judge. Dilip Parida.
Similar footing matter, my lord, for the appointment of the psychiatric.
Yes, Your Lordship have decided.
How many days of delay? 51 days. 51 days. We will condone the delay.
Yes, ma'am.
With that observation also, the similar cases will not be disposed of. By condoning the delay, man has passed the order by.
You appear forward. Sister is arguing well. This in fact would appeal. Go to the impugn order. whether state and its officials seeks to call in question a learned single judge's order dated 5/3/2025, whereby respondent employees WPC number 538 of 2025 having been favored, the following relief has been accorded to him. Paragraph 5, 6, 5 and 6. 5 and 6. Next paragraph. Appeal has been filed after booking a short delay of let's stand here. So that she is performing now. Let me sit down. Yes. A short delay of 51 days. And an application in IN number so and so supported by affidavit is moved, seeking its continuation. First one. Delay being short and explanation being plausible, comma, the subject application is granted and accordingly delay stands condemned. Next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we are broadly in agreement with the submission of learned counsel Srimati
Sai Sangeeta Rai.
So appearing for the respondent employee that the subject matter of this appeal is substantially similar to the one in the oneness in writ appeal number 768, 770, 771 Roman and 800 of 2025 between the state of Odisha and others versus Liku Panda and others, disposed of by us, wide order dated 15/1/2026 by dismissing a bill of the kind. Keeping first up. That matter has been disposed of. The cognate matter has been disposed of, keeping in view the decision of Apex Court in K. Manjushri versus State of Andhra Pradesh, 2008, 3 SCC 512, and other rulings as well. First one. In the above circumstances, this appeal is liable to be and accordingly dismissed, coupled with a direction to the appellants to give effect to the order of the learned single judge within an outer limit of 8 weeks.
Item 23 has been adjourned. Item 24, WPC 23219 of 2013.
It will go to another bench. It goes to another bench, na? Yes, 23 will go to another bench. The lordship's order is not tender.
Yes.
Yes, item number 23, your lordship. Lordship,
23.
Yes, sir. Lordship 23, they have not solved the copy, your lordship.
23.
23.
They will not.
It is again
23. I am the author of
other bench.
Okay. Next.
Item 24.
May I please, madam?
Yes, sir.
Petitioner has a very limited grievance for lordship's products. Hear me, Lord. The railway department acquired the land of the petitioner in the 2005.
2005.
Again, paragraphs. As per their notification by annexure 2, my lord, railway issued the land loser be given appointment for towards their compensations of land. By virtue of
There is such a clause.
yes, my lord, that clause, my lord.
They are not given that.
No, not given. Petitioner, my lord, this my lord, approach between earlier this Honorable High Court remitted back to the Central Arbitration to consider the case, my lord. There, my lord, petitioner, the younger brother, who is a physically disabled, my lord. He said, my lord, I am the being brother, elder brother, so my brother may be given
Appointment.
Appointment, my lord. For railway, the Honorable CAD, my lord, they rejected the petition that the brother is not coming under the family of the petitioner.
The brother is not coming. Brother's land is acquired.
Petition court held, brother is not coming under the
Whose land is acquired?
petitioner land. Petitioner requested my brother may be given appointment in his place.
No, we must one by one. Where is the acquisition notification?
Notification, lordships, my lord, I draw lordship notification is not. That annexure 2, my lord. That is the one is the annexure 1 is the order of a
Brother, you appear for your friend appears for a
my lord. Here, my lord.
Union of India. My land do you have? Thank you. You do not mind anything. Whose land you have acquired?
Rakesh Kumar Sahu, the petitioner's land was acquired.
Petitioner's land was acquired.
He had given the application for his appointment for his brother. Instead of himself, he has given for his brother.
No, brother said, I do not want you, give it to my brother, owner of the land.
But as per the railway board notification, only spouse, son, daughter, and the land user is eligible for getting the job.
He is land loser.
He is the land. Land outstanding. And thereafter, Honorable CAT rejected that way, and he had challenged here in 2013.
Yes.
And then for non-prosecution it was dismissed, and even CMPL it was restored. And by that time, in 2019, another railway board notification came out where all these schemes for compassionate job for land ousting was removed.
Removed a bit earlier with retrospective effect. All those who were appointed already, did you send them home?
No. Those were appointed.
Therefore, those whose claims were pending. See, look at that Darwin bench judgment where we have that identity. Do you have that judgment?
I have got one judgment, Sanjeev Kumar versus State of Haryana, where it is opined that Honorable Supreme Court opined that it should not be applicable retrospective.
Huh?
I have got the judgment.
Not applicable to retrospective. Retrospective. That goes against you.
No, it goes against you.
How?
Because
there was a scheme as on the date land was acquired. The land was
acquired in the year of 2005. The notification came in 2010.
10. As on the date it was acquired, it was not the case. There was no such condition.
There was no condition. Already compensation was
my lord
was paid.
I draw lordship annexure 2, my lord. What their condition, my lord.
Annexure 2 is dated what?
My lord, that is page number 9 of my writ application.
That is 10 in 2010.
10.
Then how can that be applicable?
But their condition, my friend Bala said that I am satisfied what she thought. They have stated, my lord, clause 7, para 7. Once an offer of appointment has been made, no further application claiming application on the ground of acquisition of the same
piece of land.
That means, my lord, and once they have given offer of appointment, they are till today they have not given the such appointment. My lord.
Where is the appointment?
They have not issued, my lord. Offer of appointment they have not issued.
Why can't you understand a little long? Why are you putting us to anxiety and anger? When your land was acquired, the law provided for payment of compensation only under section 21, 22, and 23 of 1894 Act. Correct? You don't agree with this?
No, not.
When your land was acquired, now we'll put questions to you. When the land was acquired?
Acquired, my lord, 2010.
Acquired in 2005. You said 5 minutes ago it is 2005.
2005.
As on 2005, What was the policy of acquisition?
Policy, my lord, Annex 2, my lord.
Annex 2 came in 2010.
That my lord, 2000, later on, that is railway, my lord, that is a route frame, that is the notification, that compensation given, that is separate thing, in addition to the compensation, appointment be given.
That was for those whose lands are acquired subsequent to this notification.
That is a judgment, my lord.
And the
some judgment with my lord, direct from the Hon'Ble High Court, my lord. This is the division bench.
with retrospective effect.
My lord.
Supreme Court said it is with prospective.
This matter, my lord.
Mr. Paddy, what is the position? You are for this matter.
I have entered over.
This, my lord, that is I am a division bench of justice headed by my lord.
This is Sanjeev Kumar versus State of Haryana.
Give that.
Yes, give it.
So that has been Supreme Court also may not confirm that judgment, my lord. Railway went, my lord, to
Cannot be broken 98. Provisions of 1994 expected.
This
Very important. Companies wait for the problems. We want to. Respect for the dictator.
Share a copy with already come to now. Read a small judgment. Read loudly so that others, youngsters are here. They will also know. Read that judgment. You copy. There are two.
Sanjeev Kumar, yes.
and on counsel for the petitioner. The land of the family of petitioner is said to have been acquired in the year 1998 under the provisions of Land Acquisition Act 1994. 1894. The family of the petitioner was awarded compensation and the same was also paid. The petitioner, who was not even born at the time when the land was acquired in the year 2025, applied for a job in lieu of the
It is not 2020, there appears to be.
acquired land.
Yes, next. In lieu of.
The request was rejected and the petition filed by the petitioner seeking job in lieu of the land was also dismissed.
Yes.
Under the provisions of the Act on the land.
What is meant by that? Under the provisions of the Act means which Act?
That Land Acquisition Act.
Yes. 1894.
The petitioner or his family is entitled only to the compensation which has already been paid.
Yes.
And there is no provision for a grant of a job in lieu of the acquired land. The policy decision, if any, of giving job in lieu of the acquired land cannot prevail over the statutory provision, and as such, we find no error, my lord. But that judgment, my lord, I have some side, my lord. That was also made our Hon'Ble High Court, my lord.
High Court is superior or Supreme Court is superior?
Also, my lord, that they have gone to Supreme Court confirmed, my lord. They are claim dismissed, my lord. Yes, my lord, I am submitting, my lord, that, my lord. That judgment, my lord.
2025 judgment.
That was
the latest one.
That is 2025 judgment, which you also cited.
Supreme Court also dismissed, my lord, their claim. Against that order, my lord, they went to Supreme Court. Hon'Ble Supreme Court, my lord, dismissed that claim.
One second.
On which date?
My lord, that.
On which date?
Have said on the same thing.
On which date?
My lord, the lordship.
1919. Acquisition is of 1999. Then 78,000 paid. Yeah. Land exchange. Without this. Under research, what you need, connected for me. This is the latest one. This judgment went in SLP.
My lord, they went, my lord, railway went, my lord. That are dismissed, my lord. That case, land was notification of the also sir 16/7
only.
2010. Similar to the petition, my lord. This is, my lord, the Hon'Ble Supreme Court, my lord. Dismissed their SLP.
Whether a reason decision or what is that?
They have cited, my lord, this, my lord, in the judgment. That SLP has been dismissed.
Get it? Is it a lengthy order or how many pages?
Now they have cited in another judgment, my lord.
You there?
10 pages. It was on decided on 14th March 2019.
2019.
14th March 2019. Thereafter, the first page judgment is coming to force. Sanjeev, go on.
That the others were given. That we got the to others.
Who has passed this order?
My lord.
Whose order is this?
This order passed, tribunal order, my lord. That
Tribunal order.
or that judgment cited, my lord. I know beginning of telling that judgment was cited, refer in that case. Honorable Supreme Court dismissed their appeal. Cited.
The tribunal has cited that.
My lord. In another case, my lord. Your lordship, my lord, my lord, submit that document tomorrow matter. So better satisfy my lordship, my lord.
If we give in terms of coordinate bench judgment, so to all those whose lands have been acquired after 1894 Act, when Britishers were here, for all of them we have to give job now. Going by this.
In this particular case, my lord, on that case, my lord, I have submitted my land are acquired, my lord. My lord, all the 3-4 persons are given appointment by the my lord. Similar case, my lord. But by present petitioner case, my lord, why they have not, why Hon'Ble High Court, they will not go before the cat will pass this order, my lord. I therefore my last session and argued before lordship.
No, those cases may not be. Here your brother.
My lord, now what the present petition, my lord, I filed, my lord, with a prayer, my lord.
Only on that ground. Not on the ground that it is not applicable.
No, I am not placing, my lord, that my brother may be given appointment. I am the land loser.
You should be given.
I may be given, my lord. So I will also directed.
In 2005, what was the age of your client?
My lord, my age of client, my lord, I mentioned, my lord, petition, my lord. That is, my lord, 28 at the 2013, my lord. Present land loser, donor, Rakesh, 28, my lord. Now the 42, 43, my lord, remaining so many years, my lord, to be servicing.
2005, what is the age?
2013, his age was 28.
He was
30, 28 plus, my lord.
In 13 years.
No, 42, 43 minutes.
Now what is your age?
My lord, no, Hon'Ble.
What is your age now?
42.
42 something minutes.
Minus 20. So he was major at this. Several laws. I've seen nobody lost 16 years. No, brother, we can't give. We refer to this judgment. Take down.
My lord, with your permission, my lord, I will not satisfy one another statement given so that I will
satisfy the other bench.
No. Your lordship will not admitted with satisfied with proper judgment with my lord, two set act, one letter satisfied, sir, my lord.
Call of the vacation.
Last occasion, lordship my lord said, what can be done in this situation? Therefore, this word was your lordship saying, my lord. What can be done in this case? Take instruction to my friends.
Handicapped about after the 2005 when you have decision of
2025 judgment of the apex court goes against you.
I have also Supreme Court that judgment will also be
But as between two judgments, the law is settled. In respect of High Court, the earlier judgment should be followed.
And that judgment,
you don't want to learn also.
no, my lord. Sorry.
You don't want to, we will not teach you also.
Sorry, my lord. No, they should not.
Law is settled. If there is conflicting judgments of the high courts, the earlier judgment should be followed, later judgment should be rejected, should not be followed. But in the case of apex court, if two conflicting judgments of identical bench strength, two judges, if they are cited, latest decision should be followed. Because of declaration of law under 141, they have done that way. Ayala, Area 2009, Karnataka. Renuka versus Tammanna versus Venakatha. Renuka versus Tammanna. Take out that section. Anyway, just look at it. That's the view. This view is expressed by Professor Lakshmi Kanta in his Precedent in English Law. Precedent in Indian law. It is in contradistinction to Precedent in English Law by Rupert Cross. Have you heard such?
No.
I can make out by your gesture.
I was trying, my lord, to learn, my lord, so that the lordships.
For that, one has to spend time in the library, burn midnight oil, burn yourself, and then Saraswati will come, not otherwise. Not like Lakshmi. Lakshmi comes by lottery. Saraswati will not. For Saraswati, she expects hard work, involvement, burning ourselves, getting disease, getting backache. Then Vidya will come. The tough job it is. Anyway, next.
Much obliged, lords.
WBC item number 25, WBC 29757 of 2020. Item 25.
May I please, Your Lord?
Yes, sir.
Order of the Central Administrative Tribunal.
The earlier council is provided part of the document. Another document I have collected from the department or something.
You give one set of documents. If you ask him, he himself will give you two sets. Order need not be. There are such advocates, very magnanimous. They need not see orders at all. I call immediately after question. Next.
Item 26, WPC 40736 of 2021. Item 26.
My lord, this case is scheduled for a hearing today. My lord, this is a case, disciplinary case for 22 and a half days of unauthorized absence.
22 and
a half days of unauthorized absence. First, I applied for 2.5 days of CL. That was regretted.
What are you?
My lord, I was working as a chief office superintendent in the railway.
Chief
office superintendent. Group C post.
Group C?
Yes, my lord. In the year, that is, I applied for 12/10/2009
due to 14/10/2009.
How many years of service you have put in?
At that time, I had completed near about 20 years of service.
23,
28.
28 years.
Yes, ma'am. My lord, I challenge the disciplinary proceeding, that is measurability charge memorandum, because the person who rejected my sale application, not entertained my leave application, that person issued me charge memorandum. As per railway rules, the charge memorandum was to be issued by his higher authority.
You are which group employee? Group C?
Group C, yes, my lord. There is a Master Circular 67, Para 2E.
Group C?
Yes, my lord.
Where is that?
My lord, that person,
Yes.
that is already stated in it. My lord, I challenged that is.
Where is the charge memo?
Charge memo is at page number 41. My lord.
41?
Yes, ma'am. Repeat page number 41.
Writ petition,
Yes, my lord.
or writ appeal.
No more, my lord.
From tribunal it is.
This is a, yes, my lord, I have come from tribunal. And my lord, this is a case which has already been dealt by High Court single bench and subsequently State Commissioner for Person with Disabilities. State Commissioner for Person with Disabilities, my lord, stated that the compulsory retirement, which is the final stage awarded to me on this measurability charge memo, that is not proper. And directed General Manager to pass further order. General Manager again applied that compulsory retirement, which is against the order passed by the State Disability.
How many days of absence? 28 years, is it true? 28 years of service he has put in. He has put in 28 years. Was there any disciplinary proceeding against him at any point of time earlier than this one?
No, my lord, there is no.
Yes,
yes.
What happened in this case?
No, we are asking question. We are asking most relevant question because those are the questions which the apex court has asked those questions. In a disciplinary inquiry, while punishing an employee, what is the length of service he has put in? Whether he has got any black mark in the service register. These are relevant factors, mitigating factors we call them. In like criminal, is a good person, this, that, etc. Similarly, see, 28 years he has served. 28 years is a long period in man's life. And without any black marks, barring the one at hand now, compulsory retirement. He remained 12 and a half days,
22 and a half days.
22 and a half days absent. Is it true? That is the charge.
Yes. About the previous antecedent or any service
What are
that
the-
I don't have that instruction.
No, which is that? See your reply. See your reply before the CAT.
Yes. It's we have filed the counter before the tribunal.
Therefore, show us.
Yes. That is the
For 22 and a half days, for a person who has served for 28 years, can you order compulsory?
I have gone through the speaking order of the general manager. That is in Annexure 17 syllabus. This is page marking in 175. 175. Let's see, please come to the 175 page third paragraph.
From the record.
From the record, yes. From the record, it's transparent that it's proceeding and
That is from 12/10/2009.
Yes,
So this 4/11/2009.
9. Term of the root procedure.
10/2009. Do procedure 4/11/2009. That is the only other. Any other charge was there? That is the only charge.
Then let's come to the 176 last paragraph. 176, please. However, yes, the matter has been examined in the light of the observations of the law SCP, which the advice of the RRT, it is observed that the railway tribunals is the advisory body.
What was the advice of the tribunal? Where is that tribunal?
May I speak?
What was the advice of the tribunal?
Advice at that time I was.
Any other punishment harsh than this? Any other punishment? It's a harsh punishment. So, consider according to the authority, consider this and give.
Why compulsory retirement? For a person who has put in 28 years he has put in.
The consequence is that if he could have properly confined to this, yes, I made a mistake. Or
assuming that he is at fault.
He is fault. That
He
was
will not confess at all.
showing his veracity for his authorities committed.
What? You should
This is the observation what I read from the records itself.
No other allegation. Embezzlement of funds, misappropriation of property, misbehaving with the women, misbehaving with the storekeepers, misbehaving with the
They
passengers.
didn't have this.
What?
But let me see for a
What that
moment.
poor fellow has done.
Only 2 minutes I have to book Lordship time. Page 177. The next page.
No, that is what is absolute nothing.
In your case, it has been seen that being the supervisor absent from the office from the second half of 12/10 to 9 without obtaining any prior permission and applied for the leave from the next day. That is
Very next day he has applied.
the next day, 13th, asking the casual leave from the second half of 12/10/2009 to 14/10/2009 and again applied for the 20 days leave pay from the 15/10/2009 to 4/11/2009. That is the continuation of your absence period being on 12/10/2009 and remain absent through the leave was not sanctioned. This is the grave misconduct and so clear.
How it will be a grave misconduct? How many times I have remained absent for more than 10 days? Do you know? This judge remained absent for more than 10 days for several occasions. He is not the managing director of is it railway department?
Yes.
Railway. Any railway was halted because he was unauthorized absent. Railways do not have heart, I can understand.
Yes.
But railway department should have heart. Railways do not need heart for running on that rail. That's true. But those who manage the affairs, they should have heart at the right place, means at the left side.
But his leave has been regretted. This is the issue here.
Why assuming he is misconduct? Shall you order compulsory retirement after 28 years?
That's why it is modified, my lord. That's why it is modified to the extent, let's say I am reading that. In view of the above, it is very clear that the advice of the RRT has already been taken into consideration in its true spirit by awarding lesser punishment of the compulsory retirement, which is reasonably.
You should have put him on the railway track itself so that the train will go on.
No, see, removal was punitive. And you just converted it to compulsory retirement. Originally, it's originally punitive because you have passed a
punitive order only. In substitution of that, you have done that.
How can you do this?
Therefore, it again is a punitive order. Rightly put.
And the period of absence could have been at best been treated as such. That's all.
Non-dice.
Non-dice.
We will not pay anything to you because you are away from this.
Only not even habitual.
Not your case. Is it not a habitual absentee?
My lord, what happened in this case, what I have examined,
will impose
each and every stage is file a case and want to get some order.
No.
By which,
how he will then sustain? You did not give him reprieve. So where he will go? He will go to the court only.
My lord,
and now because he is going
so
to
many
court.
occasions, there in each and every step in inquiry stage, in proceeding stage, is coming to the court. ask something to get some order.
See,
Then what happened? That's why this
Brother,
proceeding could not be conducted
Yes,
properly. Yes.
going to court and going to temple does not need any
Yes,
permission.
that part I am considering. Yes.
It's a 28 years, 1 lakh rupees cost. The concerned officer should pay from his pocket. Employees, we are not East India Company. I am again repeating, we are a welfare state. An employee has worked for 28 years. We have harassed him in court. We have harassed him before the tribunal. We have harassed him before the appellate authority for 12 and a half days. One who has put in 28 years of spotless service. 1 lakh rupees
That
cost.
part I didn't have instruction.
We don't need your permission for imposing the cost.
No,
We will
that
extract
part
it.
I am not standing. What I am saying is regard to the previous antecedent or
No, you cannot be. That is not the part of the order at all.
Yes.
What I cannot improve that.
What I am submitting, then to after this inquiry proceeding or the proceeding of the case, the petitioner did extended all sort of cooperation to the authority concerned.
What they could. For proving the charge. You can hold the charge
proceeding, my lord.
You can hold the charge proved. Can you order compulsory retirement?
That is, I will leave to the
His
court
wife
to
and
decide.
children will never get into your railway. They will go to some other railway. Or they will go by walk in protest. 1 lakh rupees cost.
But he is adjusting a different forum. They all have dismissed this act. It is not that.
All have dismissed means all have erred. That is the reason he is before us. If we also err.
No. I am not
we
saying
will
that.
not err that.
What I am saying is the conduct of the person.
Where is the conductor absent for 12 and a half days? That is your charge.
We are confined to our record.
It all started from there, no? It all started from
They are
this.
egoistic. Officers are egoist. Ego trip they have.
It is a vice versa also. Both sides they are going that way. That's why
the employee be egoistic, but the employer should not be. Judges should not be egoistic. We judge cannot be.
Sometimes equality principally they should stick. Otherwise, nobody will under the control.
Correct. One increment.
Something is required.
One increment.
Let's say they can reduce on that.
Even one increment with cumulative effect would have been a major penalty.
Major penalty. And you have sent him home only. This is too much. Which of your trains are coming on time to the station? You are made us to wait there. 1 lakh rupees cost.
That part
cost. No. Otherwise, message will not go. Otherwise, your officers think like babus. We don't agree with that. We are all human beings. One fine day we are laid at the smashan.
And
awareness is lacking
about this all these proceedings. About the
if you come back, we'll do one concession. We'll show because my brother is advising that on 22nd, if you come out with a clean chit with all back wages to him, then in otherwise back
Give
wages
some time, then I can
reinstate. No, again, we cannot
on
make
22nd ultimate case take it, but I will take instruction from the notice.
matter was heard for very, very long period. First now, learned DSG wants to confer with his clients as to whether something can be done in the matter in as much as the punishment awarded for a simple, maybe culpable act of remaining unauthorizedly absent for 12 and a half days, 22 and a half days is highly excessive. Excessive. First of all, call this matter on 22. Yes. 20th. 20th. Yes. We may, yes, we are likely to impose heavy costs so that never it should happen to any employee. It is one sample case before us, but message should go to the officers. They are not supposed to treat them. They should treat them with respect, love, and affection. 28 years he has put in. It's the prime of youth. After 28 of years putting in, what will remain in the body? Everything is crushed actually. This is a very unjust order. Let us see.
So two special notice. Two special notice.
The special notice. Those two matters, not yes, yes, they are covered by judgment.
This one.
I have gone through.
Today, item 20.
Item 20.
Morning hour, item 20.
Same order. That's it. Have you changed the?
Well, let the order is same.
Then
Only the cost title will.
how many days delay?
Here, my lord,
What is
the
Will condone them.
yes, item 124, my lord. And the second one is 470.
Yes.
Item 27, WPC 7272 of 2022.
27 by your lordships. Lordships, I'm praying for an adjournment and for your lordships. My learned senior is here, but he is, my lord, before the Honorable Chief Justice. The matter is going on. So therefore, I just pray, my lord, any other dates, I'll be grateful to your lordships.
What you do?
May I suggest something? The workman is not getting the suspension allowance, Lordship. Just for 2 minutes, Lordship. Just for 2 minutes, Lordship. There are 2 writ petitions, Lordship. The major controversy involving this writ petition is that he has filed 2 separate cases as 2 different forums, Lordship. One before the Learned Labour Court, Sambalpur, and one before the Joint Labour Commissioner, Bhubaneswar, Lordship. So they are saying that. So they are saying, Your Lordship, that it will lead to multiplicity of proceeding, Your Lordship. What I am suggesting is, Your Lordship, let both the matters be taken up by the JLC Bhubaneswar, Your Lordship. I have no objection to that, so that the writ petitions can be disposed of and the JLC will decide it on merits, Your Lordship. Yes, Your Lordship.
No, my lord, I am for the petitioner because, my lord, here we are challenging one of the orders of the Labour Court where a proceeding was initiated under section 33C2 of the Industrial Disputes Act. Your lordship, there a petition was filed regarding the maintainability. So, my lord, these 2 writ petitions, one is the 7272 and other is the 19165. My lord, both the things, as far as
Yes, Your Lordship, both the matters are pending, Your Lordship.
both the matters are pending, my lord. So, my lord, there.
The maintainability issue was raised there.
Your lordship.
That is the negative.
Your lordship.
Then up to let the main matter be decided and then to come before the court.
My lord,
Very for maintainability one writ petition. Afterwards, some merits another writ petition. That is not the.
No, my lord. Actually, the maintainability was filed on a particular ground, your lordship. That your lordship know that 33C2 application is maintainable under 2 contingencies. Either there is a settlement that was taken, my lord. Your lordship. My lord.
Decided in since we have adopted the order 43 rule 1 capital A
to the writ proceeding. In the event that order goes against you, you can put in challenge like this order.
Milords, I just pray, Milords, if the matter is taken up for final hearing, so Milords, this is Milords, because we have got, Milords, because I'm not even having a brief, which I also informed to my learned senior also, because my senior is supposed to argue this matter. So Judge Milords, what I gathered is, Milords, I just gathered from the writ petition.
Yeah.
Definitely, Milords, I just gathered the knowledge by just because my learned senior only supplied his writ petition. From there only, Milords, this much I gathered. So within a few seconds, Milords. So that's why I just pray, Milords, any date it will be fixed. It will be just, it is a part heard matter. Milords,
See what the in that judgment fixed court said, only on maintainability, if it is decided, if it is decided in your favor, very good. If it is decided against you, you should await the final decision. Then the order which held against you on maintainability can be made a ground for laying a charge to the main order itself.
Your Lordship says, speak about the DP Maheshwari case.
No.
Hon'Ble Apex.
No. I would conclude that. It's Order 43 capital A amendment to the CPC, which is made applicable to the proceedings. It says, any non-appealable order, if passed during the pendency of the main proceeding, it is open to the litigant to lay challenge to that order if the main matter is decided against him.
Lordship, then, Milords, because that matter is, Lord, that is. Your Lordship, it's
Amount due from an employer.
Amount
Your
is
Lordship,
60,000.
Milords, it is a separate. Milords, that is, Milords, I'm not even having the file. If I would have the file, I would have definitely to argue before you.
Where is your file?
Milords, actually, the thing is that I'm Milords, not Milords.
You're a proxy counsel.
No, Milords, I'm not a proxy counsel, Milords, on behalf of my senior.
Anyway, you are spending a lot of time in the court.
Milords,
So many lawyers are waiting and you can't spend the time
Your
in
Lordship,
court
Your
that way as you want. I'm just reluctantly adjourned by 2 weeks. First off, prima facie, we feel that no relief can be granted in this matter. Yes.
Milords, the interim orders to continue.
However, interim order is continued till next date of hearing.
Very good.
Yes.
Item 28, 8 April 239 of 2024.
Here,
Yes.
let's say appeal. I'm just state appeal letter.
Your appeal or state appeal?
State appeal.
Then he should argue or you should argue.
My lawsuit direction. There are 2 files.
Anxious and that is how they lose the case in this court.
The dates he has given one. My lord, there is an appeal wherein the order dated 2/12/2022 is impugned, my lord.
Chandramohan Negi is followed.
My lord, here in this case, Balabhadra Machi is followed.
Indeed.
My lord, it is agreed by Lord Counsel for the parties that the issue involved in the writ petition is analogous to so and so Balabhadra Machi. In nutshell, my lord, the fact remains. This petitioner was engaged as education education volunteer earlier. Upon abolition of this scheme, he was adjusted against the post against Gana Sikhyaka on pursuant to the resolution.
What was your stand before the learned single judge?
Learned single, the stand was.
Yes.
Lord, I'm coming to that. He was engaged as Gana Sikhyaka. While continuing as such, in the resolution itself, it was clear that he is to complete the training qualification, that is CT or BT, whatever. And thereafter, 6 years thereafter, he will be regularized. Subsequently, thereafter, the 2009 RTE came, Right to Children's Education Act 2009 came.
That is interpreted by the apex court.
Apex court.
What apex court said, the latest judgment last week, another judgment came.
I was.
That it is essential.
Yes.
That qualification is essential.
It is essential TET. TET is essential. Here in Odisha, we are saying that it is OTET.
OTET. Because they have done OTET.
OTET. He has not completed OTET. Your Lordship wanted to know that whether it is for the state of only Maharashtra or...
No, apex court said it is for the whole country.
For the whole country. That's why I want to place before your Lordship the paragraphs 214 to 218, my lord.
To contradict what we said now or in support of that?
In support of.
Why are you reading? When court is in your favor on a particular point, still you want to argue the matter?
No, I want to go with the judgment of the honorable.
Latest judgment last Friday matter came.
No,
it appeared in live law. It appeared in live law. Verdictum. In verdictum, this matter has been considered. Just some clarification is made. Look into and come back. The verdictum it is reported.
My one line submission, my lord. This honorable single judge judgment was based on government decision. As I have supplied the same.
Correct. Now the apex court decision has become, that becomes the law under Article 141.
Just 1 minute. They in that cabinet decision that was signed by the governor, that was still in force. So if they file the writ appeal, that is against our Constitution 166 of that provision. Because that is governor's order. That is not in force. That is still in force.
Now the apex court says in all schools, this is the requirement.
My lord,
latest judgment of the apex court it is. Therefore, instead of now only allowing an appeal and putting you to problem, you may go through that judgment and come back. If it is in your favor, we'll dismiss the appeal.
In that also in their gazette notification, that also taken care of.
Which judgment? Last Friday's judgment?
That the government notification.
That makes no sense. They have interpreted the provisions of 2009 Act. After that, they said, our prescription extends to whole of the country. They have said that. Therefore, now there is some little modification which may be of some help to you. We don't know. This judgment is not last Friday's judgment.
No. It is quite...
Last Friday, another judgment has come by the larger bench. Just look into it and come back. That may help you also. We don't know. Otherwise, now we have to allow the appeal. Then you will lose everything. Yes. All after vacation.
Item 29, read appeal 2364 of 2024.
My lord, I am praying for an adjournment.
You are praying for adjournment?
Yes, ma'am.
But what is the way this matter was posted today?
My lord, due to unavailability.
I am appearing for the opposite party on behalf of Mr. A.K. Bose. Mitra Sampos.
After vacation? At the request of both the sides, call after vacation. Number vacation.
Item 30, read appeal 2699 of 2024.
Yes, sir.
My lords, the respondents, gratuity and other benefits were not given.
Have you given 2 books to the library?
My lord.
Which are those books you have given?
Your lordship modified that order. After that, they have given.
Which books have been given? When they have been given? Which books were ordered to be given?
My lord had ordered. My lords, it was given on
Last occasion they had submitted a
Law
receipt.
of injunction.
They are asking a question.
Law of injunction by Nelson.
By Nelson.
11-5 it was given.
No, 26-3. 26.
No, 4-5-26 book was given. My lords.
No, given already.
Yes, my lords. This is the receipt.
No, if you
We
say
have got
you
those.
ask, not doubt you. Yes.
We have given.
Last occasion, my lord, had heard this matter, my lord.
No, we don't remember.
The only question was that whether on the date of retirement, if a charge sheet has not been filed or not on the last date of retirement, whether the petitioner is, whether the employee is entitled for pension and gratuity, whether on the last date of retirement a departmental proceeding is pending or not, or a vigilance proceeding is pending or not. Subsequent amendment to OCS pension rule has come out, my lord, where it clearly says if a magistrate has not taken cognizance of a charge sheet
My lords,
on
I
the
am-
date of retirement, my lord, I have got the notification.
Let him say.
My lords, there are two rules governing
The facts, foundational facts.
my lords. The petitioner,
Employee.
well,
He retired on which date?
My lord, retirement on 31/3/2020.
30 March 2020.
2020.
30 months. It cannot be 31 months.
30 March.
Huh?
How can it
30th
be?
March.
No.
It cannot be. Only constitutional authorities retire on the
It
same
has
day.
to be on 31st.
It must be on the last day of the calendar month. Anyway, we'll take it as 31/3. 31/3,
2020.
2020. Whether
On
any
30
DE was initiated. Disciplinary proceedings were initiated.
My lords, a vigilance case was filed.
Was initiated.
My lords.
Vigilance case was initiated means what?
31/1/2017, vigilance case was registered, my lords.
DA or
DA.
DA.
Registered means FIR was registered.
Yes, ma'am.
When a criminal case is said to have been pending for the purpose of disciplinary
My
proceedings.
lords, there are two rules. Rule 7 says that specifically there is unless cognizance is taken, it cannot be treated as pending at all. But Rule 66 is independent, my lords. There such a provision is not there. That taking of cognizance will be treated as pendency of the vigilance case or criminal case. Rule 66, my lord. Both the
Which is the earlier rule?
7C.
7C.
My lord.
It speaks about pendency of criminal case.
Yes, my lord.
It is for what purpose?
That is for the purpose of withholding or withdrawal of pensions.
And another, this rule is rule
66. 66 is for provisional pension and withholding the gratuity. That aspect was not considered by the learned single.
No, another rule is
66, my lords.
66. 7. Let us read rule 7.
7, my lords. My lords, 7C.
7.
C is important.
7C.
C.
7 capital C.
My lord.
Capital C is not.
3C.
Capital 7 capital C is not there.
No capital C.
Oh, small c.
Small c.
7 2C.
2C.
C.
7 2C.
No judicial proceeding.
My lord.
If not,
It bars institution of
My lords, explanation is important. For the purpose of this rule,
no, read that. Annexure C, that clause C subsection 2 of rule sub-rule 2, rule 7. No judicial proceedings.
my lord.
Will it include a criminal proceeding also? Judicial proceeding, criminal proceeding,
My lord,
also
it is
judicial
stated
proceeding. Yeah.
later on. No judicial proceedings if not instituted while the government servant was in service, whether before his retirement or during his re-employment, shall be instituted in respect of a cause of action which arose in respect of an
Or in respect of an event
which took place more than 4 years before such institution. In the case of government servant who was retired on attaining the age of superannuation or otherwise, and against whom any departmental or judicial proceedings are instituted, or where departmental
no, this may not be applicable because departmental proceedings are not instituted.
instituted
In 2017.
no 2020
After retirement.
after that. My lords, what I bring your lordship notice to the explanation. For the purpose of this rule, departmental proceedings shall be deemed to be instituted on the date on which the statement of charges are issued
To the government servant
or pensioner, or if the government servant
has been placed under suspension from the date of his suspension.
Then my left B.
Was he under suspension?
My left B is important.
No, we'll come that. We want to know. Was he under suspension?
My lord.
Was he under suspension? No.
I retired. On attaining age of superannuation.
No, even a suspended employee also retires. So that's another thing.
No, not understood.
No suspension.
That I will.
Now you want to read us which?
B.
B.
Judicial proceedings shall be deemed to be instituted. In the case of criminal proceedings, the date on which the complaint or report of a police on which magistrate takes cognizance is made. And in case of my lords, this is for the purpose of this rule only, my lords, it is written.
Correct.
My lords. 66.
It's island provision, independent provision.
My lords.
How various judges of this court have interpreted these provisions all these years.
My lords, the 66, my lords.
6.
Where departmental or judicial proceedings are pending in respect of government servant on the date of retirement referred to it, he shall be paid provisional pension not exceeding the maximum pension which would have been admissible.
66 provides for grant of provisional pension.
Provisional pension, and second, 66(2), no gratuity shall be paid
to the government servant
until conclusion
of the department
or
judicial proceeding and issue of final order thereon, provided that the department has been instituted. How these provisions, Rule 7 and Rule 66 appear to be cognate provisions. They speak of one subject matter. How various judges of this court have interpreted these provisions. These provisions came in the year 1992. In the last more than 30 years.
66
not interpreted.
66(2), your lordship has also stated that it is not payable till finality of the judicial process. My lords, I have not that.
My lord, I have come up with the resolution that they have passed, the Home Department, and I'm supplying the copy. My lord, let me see how they have interpreted and they have clarified.
But if the rule, whether interpretation of a rule by the rule maker.
Amendment is, my lord. Amendment is
amended.
Amended.
Copy. Rule 7 has been amended.
You there?
Rule 7.
My lord, may I kindly see? I have marked the page numbers.
You copy.
Madam, may I kindly see page number 3? I have marked it.
Yes, 3.
Yes, madam. Page number 3.
Item 2.
Rule 7(2), my lord. That, my lord, that clarifies when the retirement benefits are payable. And, my lord, on the top of the page, it has been written that the OCS pension rules have been amended and these are the new provisions. For ready reckoners, they have mentioned that.
Where is the amendment?
My lord, amended as per the notification. On the top of the page, my lord, it is written 19/5/2025, if I'm not wrong, my lord. The top of the page, my lord, it's written.
With effect from 19/5/2025.
And that has been
This
mentioned.
amendment takes care of pre-amendment cases also.
Yes, my lord. But pre-amendment cases here, the amendment was just for a clarification, my lord. There, my lord, they have clarifically mentioned that magistrates should take cognizance of the charge sheet. Then only it can be said that a judicial proceeding is instituted, my lord. That is the language of Rule 7(2) as well.
That is for the purpose of
That is for the purpose of that rule.
Yes, my lord. Yes, my lord.
That is only for not institute or not to institute.
Yes, my
that
lord.
way.
My lord.
But for payment of provisional pension and gratuity, separate provision is there.
Provisional pension I'm getting, my lord.
That's all.
That I'm not disputing.
Gratuity you are not getting.
No, my lord. Not
Because no gratuity shall be paid to the government servant until the conclusion of the departmental or judicial proceedings and issue of final order thereon.
Yes, my lord. Until the conclusion of department proceeding and judicial proceeding. My lord, I am placing that. Until the conclusion means there has to be a beginning of a proceeding. And when my lord,
that is only for the purpose of Rule 7.
Yes, my lord. That I am stating, my lord. There has to be a particular beginning, and the beginning is the institution which has been defined. That when a charge sheet is filed, that can be said. A mere registration of FIR or a mere case under investigation cannot be sent as institution. That my particular submission is there. In that light, man. Because Rule 7(2) is clarifying when is the institution. Rule 66 thing conclusion.
7(2) is clarifying. It only says no proceeding shall be instituted. One that is limitation of beyond particular period. Then for that purpose, they have said when a proceeding is deemed to have been instituted.
Yes, ma'am.
That is for the purpose of taking action.
Rule 7(2).
This is for the purpose of giving the terminal benefits. There are two different tasks.
Yes, my lord. No, my lord, here what I am submitting, my lord, may kindly see that what I have supplied, my lord. Here, my lord, may kindly see. Rule 7(2), I am reading it, my lord. Provisions has been inserted that regular pension, gratuity and other retirement benefits can be sanctioned if magistrate has not taken cognizance on the charge sheet filed in a vigilance case. My lord, is the finance department resolution, my lord. Is the finance department on dated 29/5/2025. They themselves are saying provisions has been inserted.
Where is that provision? This is their version.
My lord, there was that is at.
No, we want to see the law.
My lord, I'll get that. 19/5/2025 resolution clearly speaks that.
No, we don't go by what. This is only the version of the
clarification that they have come.
In one judgment, Justice O. Chinnappa Reddy said, if there is any confusion as to the interpretation of the rule, how the rule maker has acted himself with this rule in the course of business, that may be one of the indicators.
Yes, ma'am.
Beyond that, nothing. These resolutions are passed by the departments, the placing some interpretation on where are the amended rules?
Yes, madam.
Where are the amended rules?
Amended rules, madam. If my lord may keep it to tomorrow, I'll get the amended rules on my lord.
Okay. Many morals are coming now. You'll have it immediately after vacation. Now, just in the meanwhile, make some research as to how various judges of this court have interpreted these rules.
My lord, already honorable coordinate benches, my lord, have passed the order and that has been implemented also. I'll get the implemented copy, my lord.
They implement because we threaten them of contempt action. If there is the interview, can we say like that? Yes. Suppose if money decree is discharged by making the payment, you mean to say no right of appeal?
No, not that.
Yeah.
Grateful, ma'am.
Item 31, 33365 of 2025.
My lords, item 31. This is a part-heard matter. Now, as AG was addressing your lordship, he is in chief court, is busy in another case.
When will you take up this matter?
Any day after vacation.
After vacation?
My whole anxiety is the elected representative.
Term will be over, my lord.
There will be no point in speaking.
Term will be over.
Yes,
When it will
by
be over?
2022, 2027 March.
22,
5 years. March
27. That much only with that.
My lords, the whole period will be he will be without any office. But today, subject to my learned friend in the government side considers it, I may request your lordship that is only point of natural justice. It may go back for a fresh constitution, that's all.
Let us.
That instruction I will take. We may agree to that.
But only on the part of natural justice, that's all. I am not going to merits, no other aspect, nothing, no submission on any other aspect.
On 22nd, you will say that.
Yes, my lord.
On 22nd.
Otherwise I will write it.
Or 20th. Many cases are 20th agreement.
Now also we have to.
Your matter also.
That
21st. On 21st, how many matters are posted? One matter. Post this on 20th.
Yes, only for this limited.
For this limited purpose, my lord.
That's
Grateful. Grateful. Interim order to continue.
Interim order. If interim order is continuous, the urgency for
We are in by-elections. Interim order is the by-election.
No by-elections in the meantime.
Yeah.
Item 32, Need appeal 514 of 2025.
See, Lordship had heard this matter on the last occasion. This is an appeal by the Commission where the correctness of the answer key in respect of one question is under challenge. But before I begin, there is a tagged matter where notice has not been issued.
No notice issued.
Yes, Manoj.
In that matter, we have to issue notice then.
Yes, Manoj. There is a delay of 34 days also.
523-25. 523.
Yes, Manoj. Challenging the same order, common order.
Issue notice. Who are the, please go to the first title.
In the first matter, my learned senior is appearing.
You will take the notice. For state, Mr. Degra. Mr. Degra, whether he requested to accept notice for 225. And your counsel, private counsel. Volunteers to accept notice for. This is a OP number.
OP1.
OP number 1. You just look into it and make submission of application.
There's an OP1 notice is to be issued.
He is appearing.
In the case number 1, I am waiting there.
In this, no.
Yes,
Issue emergency notice to OP number 1.
Oh, this is a different person.
Yes.
Great.
Item 33.
Can we proceed independent of the other case or we will take?
No, together we decide. Same matter, na?
Same.
Yeah. Next.
Any particular date, sir?
No, service has to happen. Yes.
Item 33, rate appeal 865 of 2025.
This is my appeal, my lord.
Yes, sir.
Challenge an order passed by this honorable court in single bench, my lord, on 11th of August, 2025. 11th of April, sorry, my lord.
Arbitral proceedings.
Sorry, my lord.
Arbitration
Yes, my lord.
proceedings.
Arbitration proceedings, award passed, challenged in a writ petition, 226, 227. None of the parties were any state authority. Well, I think that it was in the nature of 227 and award set aside.
Award is set aside on what ground?
On the ground, my lord, that, my lord, there was perversity. That is the specific finding. And I'm relying on this word perversity because, your lordship, this is the ground specified under section 34.
So therefore, they have to go to 34.
That is what will be my preliminary argument, my lord. So, my lord,
Your lordship, if I may, your lordship, that 11/4/2025 judgment had been passed. After that, a review petition had been filed by the petitioner. That already has been allowed on 29/11/2025. To that effect, I have already filed a memo with the review judgment, which is on record, your lordship, on 6/1/2026. So hence this present appeal right now has become infructuous because they haven't challenged the review order. Because it was a judgment where the parties has to see. I have already placed it. It was what you get. It is already there, your lordship. It's here.
Review is allowed.
Yes, your lordship. On many counts, review has been allowed because here what the party has done is that
without service,
वो सर्विस गया है ऑफ कोर्स नहीं
just look into. Okay, so my advocate is here, Malad. He's saying he never received any notice. So Malad, I will update in the blue.
Notice were issued, notice was sufficient, and to make sure that they will come, I personally met the opposite counsel. I told them about the review. I had in fact mailed. I have that mail, your lordship. I have a mail where I have stated that the next date of hearing is on so and so.
Now now the order which is challenged here is recalled.
It has been modified, your lordship,
to the effect
that earlier what happened, the award was passed not only on an unstamped agreement, despite the court order that it should be impounded. Still then they didn't cure it. And the opposite party was supposed to cure the defect because under the Stamp Act, it is always the lessee. I am the lessee, your lordship. And thereafter, both the parties had already waived their right to arbitration by going to the civil court.
They have gone to the civil court?
Yes, your lordship. After filing their civil suit, I appeared and I filed my written statement. It is always your lordship knows, it is always the prerogative of the defendant to whether to go to arbitration or not. So in his suit, I appeared and I filed my written statement. Thereafter, they withdrew. And the same prayer was before the arbitrator. I filed my civil suit 462 of 2017. They filed a section 8 despite their own pendency of their own civil suit. And in the meantime, the High Court had already rejected their prayer for time extension twice. Despite that,
so they were looking to.
Well, I have understood what he has done, Malad.
Your lordship,
this has been going on for some time now. Malad, what has happened, Malad? The learning
in view of this order.
Malad, may I file a supplementary memo? That is maximum I can do.
I feel.
But what has happened? I'll just one minute, Malad. Malad, the original order was setting aside. After impounding, it should be stamped, and then the arbitrator should again start. Now, in this review, Malad, what I have found is it's a complete order. Everything set aside, no further steps to be taken by the arbitrator. This is the only limited scope, Malad.
Therefore, your appeal does not survive at all.
Malad, my appeal will survive because the original award has been set aside.
Huh? No.
The original award has been set aside.
No. Coupled with the direction.
Coupled with this, Malad.
You have to fight out, the party should fight out their grievances in the civil court in CS number so and so.
No, Malad.
Yes.
Yes, that is the order.
Malad, I am challenging that.
That order itself you are putting in challenge now.
Because, Malad, I did not know about this. Well, the first order which is under challenge, my lord, is a simpliciter setting aside of the award.
Correct.
Now, my lord, he has filed a review. What I find from this review, my lord, I just read, my lord. Many things have been told, my lord. I'm being directed by the judgment, my lord. The last sentence says, it is reviewed to the limited extent that the direction permitting continuation of arbitral proceedings after stamping is recalled and set aside. As a consequence, the arbitration initiated under the all proceedings orders of the learned arbitrator shall stand terminated as non-est in law. Then says dispute in the party shall be adjudicated in civil suit number such and such pending before the court of additional judge. So, well, this is my challenge.
Now, even that order you have to challenge.
Well, now I'll also have to put in a memo for this.
Otherwise, not memo, separate, you have to file a.
Well, it's separate appeal, madam. Sorry,
Okay, you have to
Calcutta, we
file
call it a
that.
memo, madam. Sorry, madam. But we put in a separate appeal, let this also survive. Let this
We
remain.
keep it. You
Yes,
keep it,
madam.
then we don't think that it will survive anyway. We will not decide it now.
Yes, madam. Because
some arguable
yes,
point
because
is
madam, this is madam, any direction by writ court to appear in the civil court. Madam.
Let us see, let us.
Your Lordship, if I mention, I have filed an application for perjury also.
We'll
Because,
consider all that.
okay, I'll just say a few things, Your Lordship may permit. Yeah, the perjury, what they have done is.
We consider.
Okay, okay.
First,
Okay.
it will be considered.
All this matter.
Second.
In the second week of July 2026. Any particular, you are from?
I'm from Calcutta, madam. I'm from Calcutta, madam.
You're from Calcutta? You want to choose any other?
Madam, it is keeping in July, madam.
Any day.
Well, if it would be the second half, it would be very nice, but I don't know whether your lordship fixes.
2nd of July.
Second.
Second week of July.
No, no, madam. Any day, but on the second half, if it's possible.
We'll give it third half.
But I'm in an urgency in this matter, madam, because I have the award. Man keeps it whenever your lordship. Not a problem.
Yes.
Any time in July, madam, your lordship.
22nd of July.
Yeah, Lord.
All right.
Yes.
Very good.
22nd of July.
2nd of July.
22nd of July.
Sorry.
Yes.
22nd.
22nd of July. 22nd.
Oblige you.
Okay. Yes.
Item 34, Writ Appeal 1359 of 2025.
Yes, absolutely.
Yes.
Nobody does not.
Yeah.
Plus, this matter, the pleadings are complete in all respects. It's going to take some time, your lordships. Take up this matter, I can.
Generally, in the last 10 days, only urgent matters alone are taken in various high courts. I do not know the procedure here.
Same is the procedure.
Same is the
Same is what?
because very urgent matter.
Only interim order matters.
Interim order matters. Are
And
taken.
not the
For
bar-
last 10 days in our
The
state.
bar also this side expects interim orders for the vacations of earning in the vacation.
For you, no interim orders are required anyway. For others, they may be. So we'll push this matter.
Lord, we have a little bit of urgency in this matter. So if your lordships put it early, immediately
Yes.
after you.
Choose one date.
Any date.
I was also.
No, since you are saying
At two-
urgency.
No.
Which date you choose?
I
Your
was
lordship
also
keep it
suggesting
immediately after vacation at 2 p.m.
any day at 2
lordship.
p.m. That will suffice because the purpose of everyone.
23rd.
20. I think we have already posted. How many matters are posted on 23rd of?
5 matters.
5 matters are. Some 5 matters are posted.
My lord, any day after 25th. My counsel is assisting me.
On
29th, my lord.
29th we'll have it.
29.
Your lordships have fixed that RPO matter to 29th, so this can be 30th.
30th. You are right.
30th, 2 p.m.
Yes.
First,
30th.
Lord, I have some difficulty. Keep it fast.
First of July.
Yes.
First.
Mr.
First of June, my lord. First of July. Yes. First of July. That's it.
Let it be 1st July.
2 p.m.
1st of July.
Your lordship may say 2 p.m.
No, 2 p.m.
We may not sit at all. It is 1st of July is Friday.
Okay.
That's the reason. Otherwise, following Monday we can do that.
1st of July is
Or as a 1st of July is Wednesday.
1st of July is Wednesday.
Wednesday.
Oh, Wednesday. Oh,
This is June. 1st of July.
My lord, the problem is nowadays with all this computerization, no junior in the office has a list. We grew up with a list to see first.
True.
Grateful.
Yes, obliged. Yes.
Item 35, Neat Appeal 1551 of 2025.
Well, it was 35, maybe taken up any other day.
After vacation, can we call that?
Yes. I'm not ready.
Small.
For you, it is a small matter.
Learned AG. Next.
Item 36, Neat Appeal 1780 of 2025.
May I please, my lords?
Yes, Mr. Secretary. Any urgency?
Well, your lordship extends the.
No urgency is there. Only thing is, the lordship has passed an interim order. By virtue of that, the OA which you have been filed by the bank is not proceeding further.
For a few days. Immediately after vacation, we'll have.
May I please pray for 1st of July?
Second, 3rd of July. 2nd of July or 2nd of July?
Don't see that side.
I'm sorry.
By that calendar.
I'm sorry. Third only Friday, second will be.
Second, can we have that?
Thursday. Second.
Ideally, third.
Third is a
Not
Friday.
Friday. We don't say that.
First.
First.
Thursday.
First of.
The interim order to continue.
Interim order to continue till then.
Greatly obliged.
Next.
Item 37, Neat Appeal 2034 of 2025.
Despite due service of notice, the respondent has not yet appeared.
Not appeared.
Not appeared. It was
Private respondent is there.
no.
Government. Government is not appeared. Government is always there.
Government, not state.
Then
Police Housing Corporation.
Police Housing Corporation is having their own panel.
They have their own.
They have their
It was 30th, as per the tracking report, 30th March was the date of service.
Mr. Behra, tell.
Yes, my lord. One of my friend appears, I will ask him.
Well, can you mention
name?
I'll tell him. Next time.
May break. A delay may be condoned, Lord. It may be posted on 2nd or final disposal.
How many days of delay?
110 days. And as per your lordship's direction, I had deposited 5,000 rupees. I had deposited towards the.
Let delay be condoned.
Condoned delay, you pay that 5,000.
I have already paid it, Lord.
Paid it to whom?
To the library, my lord.
To the library you have paid?
My lord.
Where is that?
The receipt is there, my lord. As per the noting.
Okay. Next other intention. Should be Yes. There is a short delay of 125 days, group in filing the intra-court appeal. First of application in IA number so and so is filed seeking its condonation. First of the same is supported by an affidavit. First of learned counsel for the appellants draws our attention to our earlier order dated 12/3/2026, whereby the sum of ₹5, a cost of ₹5,000 is handed to the Orissa High Court Bar Association library fund for buying books. First time. Condonation of delay would not add extra merits to the case of appellant to the prejudice of the other side. First of the justice of the case warrants that delay be condoned. First of application is allowed, and delay is condoned. Okay.
May I pray on 2nd of July?
2nd of July. What any urgency?
I was dismissed without any hearing, Lord. Natural justice is valid.
When you were dismissed?
Dismissed?
Long ago.
1.5 years back. So any day
First week.
prior to your
First week of August, the third week of July 2020, it will come. Yes.
Item 38, WBC 28118 of 2025.
I will present already filed on the evening with the.
We call it off.
My lord, I am another case along with the 3 to 4 proceedings.
Yes, sir.
This is a case they have already implemented. Tribunal has passed the order by following the judgment which has been confirmed by the Supreme Court in series of cases. And both the applicants are retired employees, my lord, senior citizens. And still they carry the case.
This order is affirmed by the apex court.
Series of cases, man.
It is a total impact of throughout India, madam. Different High Court has been passed a different order. In my learned friend which has been mentioning, that has been interpreted by the Madhya Pradesh High Court and held that it is the judgment which has been on the basis of which the tribunal of matter side that has been passed, that is for imperium. All I have to address on that matter. That's only question of law. Any date after vacation, that is also interpreted along with all these documents. The reason I am filing to already file on the website, ma'am.
With your lordship's kind permission, if my lord will kindly permit me, I will just take your lordship to one judgment of the Honorable Supreme Court. My learned friend is saying
that is interpreted by Madhya Pradesh High Court.
Yes, exactly.
That is not Madhya Pradesh, Rajasthan High Court they are right now relying upon. And the Rajasthan High Court has not taken into consideration any of these judgments. Lordship may kindly come to page 75. Page 70, just go to second column, go to document.
Judgment.
I will have it.
Only one document, let me show to you, Lordship, my lord, page 75.
Union of India versus Rajasthan.
My lord, that, your lordship, you will go to second. Page 75 of the brief, your lordship may kindly come. This is the first batch of cases across all over India, my lord, and India. The case was filed, original case was filed against the Madras High Court judgment, and including our High Court judgment was there. Almost 3-4 High Court judgment was confirmed by the Honorable Supreme Court in this case, man. This judgment has not been referred to in the Rajasthan High Court judgment, which they are relying upon. That part, my lord, the very issue, whether the issue is this, my lord.
Listen first. See, delay is condoned, no leave is accorded.
Yes.
It is dismissed as a threshold. Therefore, it does not get the approval of the Supreme Court.
But fact remains, my lord, all these orders has been implemented by the department, and thereafter also, at least 50 or 60 cases, they were carried to the Supreme Court, and Honorable Supreme Court confirmed all those orders, and those orders have been implemented by the East Coast Railway itself. And I have annexed those documents, my lord.
On this matter, on 20, how many matters are questioned? 23rd of June? 5 matters. Put this also. On 23rd, yes.
All right, I'll compile that all this.
Wherever matters are covered.
That only.
Be fair. Unnecessarily taking penalty will not help you.
Interim order to continue.
Interim order to continue in 23rd. Yeah.
Both the cases.
Next.
Item 39, WBC 28708 of 2025.
Yes, sir. This matter can be taken up.
That's only the special prayer that the opposite party for whom I am appearing, he is in the last stage of the cancer. So he may or may not survive by the end of this vacation. So Lordship may fix 24th.
24th of June. All right. And how many matters are questioned? One matter, then nothing. 24. I go to have posted one.
2 matters.
2 matters. Like, no problem.
Interim order.
Interim order 2 matters.
Interim order, my lords, in the second bit of the writ petition, that is 23693.
Yes, yes. 1 second.
Interim order dated 8/9/2025.
Wherever interim order is already granted, that is continued.
Yes.
That's
Item 40, WBC 2554 of 2026.
yes.
May I please? In this writ petition, petitioner is challenging illegal arbitrary order passed by the Learned DM, that is Annexure 6, page 26, my lord.
Notice was not sufficient, then opposite parties.
Addressee left without instruction, hence returned to sender. Fresh notice to be taken. In the cause list, you have mentioned the service is not a service of notice not happening.
The main grievances with the DM, that notice is there. Other parties is not required because this
Then
is.
you file memo, we'll delete them at your risk.
That will find.
Will you file the memo?
No. But we have kindly permitted 1 minute. Sir, to submit. Here it is whatever, when the bank charge is continuing over the property, when bank got the decree from the DRT, and accordingly when bank is proceeding, when with the last stage we have got that property has been attached by the DM with a plea that some supply department has to recover from that by selling that property. And it is clearly, I have already annexed.
Covered by judgment of
Judgment there. Our own High Court, I have annexed it.
No, Apex Court judgment.
Apex Court judgment is there. That also I have been taking
free
refuge
from all encumbrances. Even state levies are also not recoverable from that property. What do you say, Mr.
Man, here another thing. The judgment I have annexed, it is exactly against the supply department. See that,
Well,
that is
same
not
department only.
Only, and that covers this. That is the whole year which I have annexed. And another judgment in my case also.
It was attached by DM under
Madam.
Yes.
DM has.
Sorry, Your Lordship, my son was in personal difficulty. My son was in the hospital, so.
Not well.
He's had a minor operation, Your Lordship.
But why have you come? You could have sent words now. No, I have this matter. When will you be able to argue this matter?
Next week, Your Lordship.
Next week may not be. We'll have it on 24th, 5 matters you have put now. This on 24th we are calling this matter. Madam has understood.
Because a lot of money is there. We have gone for the option.
24th. You came only for this purpose. I think that judges do not have heart to
No, Your Lordship.
Sir, that cannot be comment before this honorable court. This court is a hurtful court. Anything, particularly advocate demands. No. You should have communicated with his colleague.
We could have sent words. Words would have been sufficient when you came. Yeah. Yes. Mr. Which matter you are?
I could tell quickly this matter. Because of the state's appeal, my lord, petitioner is not able to get the fruit of the judgment, input judgment. There is a delay of around 2 years. It has come for orders only.
2 years delay.
2 years delay. Almost 2 years.
Let us see next coming.
Deprivilege.